Thank you.
Chief Justice, members of the court, I'm going to make oral submissions on behalf of Parliament ahead of counsel for the Minister, if that's in order with the court.
Okay, that's fine.
Thank you. Thank you.
Your 30 minutes starts now.
Thank you. Members of the court, there are two issues that arise from the OSA's submissions. The first is the question of signature, and the second is the question of the recalculation. If I could perhaps just make clear up front, I don't intend dealing with the issue of the recalculation, and I don't do so for a few reasons. The first is I understood that when Justice Rogers put the question to my learned friend about whether it would be appropriate for this court sitting on an urgent basis to determine the issue of recalculation, she appeared to accept that it wasn't. Secondly, in any event, it wasn't dealt with in oral argument, but if the court is inclined to reach that question, then we've dealt with it in our heads of argument, and Mr. Butlander will deal with it in oral argument to the extent necessary. I am going to focus the bulk of my time on the signature requirement, and I'm going to make a few submissions in relation to the Amicus submissions, members of the court. So I thought, on having listened to the debate yesterday, I thought it would be helpful to start by just articulating the challenge in respect of the signature threshold. The first point is this, members of the court. To the extent that there may have been any uncertainty, counsel for the OSA made clear in oral argument yesterday that this challenge is founded on a rights infringement. We understood her to say quite expressly that she disavows any reliance on the principle of rationality, and it really is an infringement of Section 19 rights and whether or not the state has shown a justification in there. And so the consequence of that, members of the court, is that there is no basis on which the OSA can pursue an argument that says a signature requirement as it is doesn't meet a legitimate government purpose, or that there's no rational relationship between the means and the ends. And so that significantly narrows down the ambit of the issues before this court on this issue. And if the court is to have regard, we understand that the point was made fairly by counsel for the OSA, because if the court is to have regard to the founding papers in this matter, it's at page 44, paragraph 133. And the court will see there that the applicants identify what the purpose of the signature requirement is. And they say there that the stated purpose of the signature requirement on independent candidates is to ensure that they have a serious intention of contesting the elections and to limit the number of frivolous candidates on the ballot. And then they go on to say at paragraph 134, this ensures that the Commission is able to run elections effectively, and it also prevents votes from becoming too complicated for voters and prevents the vote from being counted, counting process from being overcomplicated. And so the court will look long and hard in the founding affidavit to find any criticism in relation to that purpose as articulated. We submit there is no criticism in relation to that purpose. And so the consequence of all of that is that the jurisdiction or this court is not engaged on the question of whether or not there's a rational basis for the signature requirement. But there's a second issue, Justices, in relation to the question of rationality, and that is the tenor of some of the submissions that were made in the course of yesterday, which was to interrogate a question of where in the documents does it explain the basis for the 15% threshold. And the argument appeared to be that absent a basis in the documents, the decision is then unreasonable and susceptible to being set aside. And we submit with respect that's the incorrect inquiry in any event. This is not a review as in the administrative law context or a legality context where one consults the record that's served before the decision maker and one asks whether the information that's served before the decision maker is rationally related to the ultimate decision that is being taken. And so we submit that to the extent that there's any engagement or was any engagement on that basis, it's a false premise for the purposes of the constitutional challenge. Justices, against that backdrop, let me then go on to the rights infringement, which is really the underlying basis for the challenge as we have it. And this court will be aware that it's trite, that there's a twofold requirement and that there's a twofold onus in relation to each of those requirements. Question one is whether the applicant has demonstrated an infringement of the right. And that, justices, is an onus that's borne by the applicant. The state plays no role in relation to that onus. The second, and of course the court knows full well that one only reaches the second, which is whether there's a justification for the limitation, and the justification inquiry is founded on the state discharging that onus. So, members of the court, just in support of that, I won't belabor the point, but I referred the court yesterday in oral argument to the new National Party judgment. The court will be aware that that judgment engaged inter alia the questions of the right to vote in relation to the barcoded ID. And it was in circumstances where, on the evidence, the barcoded ID was available to 80% of the electorate, and the question arose as to what were the implications in relation to voting rights, etc. And it was in that context that this court very helpfully analysed what's required in discharging the onus. And justices, I refer you in that context to paragraphs 20 and 21 of the new National Party judgment. As regards the infringement of the right, members of the court, this court said at paragraph 20 that when there's an infringement alleged, the onus is on the party alleging it to establish it. And the court then went on to say that any scheme that's designed to facilitate the right carries with it the possibility that some people will not comply with its provisions. But that, this court said, does not make the scheme unconstitutional. And the court then went on to articulating the question as follows: the decisive question being, when can it legitimately be said that a legislative measure designed to enable people to vote in fact results in a denial of that right? And when a party alleging that an act of parliament has infringed the right, they're required to meet that threshold. The court then went on at paragraph 21 to say that the exercise to be carried out by the court entails an evaluation of the consequences of a statutory provision. And further down it said that Parliament must ensure, in relation to the right as invoked in that matter, that people who would otherwise be eligible to vote are able to do so if they want to vote and if they take reasonable steps in pursuit of the right to vote. And so the takeaway from all of that, justices, is that an applicant doesn't discharge the onus for demonstrating a rights infringement by simply alleging a right has been infringed. In this matter, the question that this court has to ask is, would the signature threshold infringe the Section 19 rights of independent candidates because its probable consequence is that they will not be able to stand for election even though they act reasonably in pursuit of that right. So having established, members of the court, that that is the question that needs to be asked, the court will then engage with the case that has been made out in the founding affidavit in answer to that question. And if I can ask the court to look at page 41 of the papers. And in particular, if I can start with paragraph 128, where the challenge is articulated as being one of the factors informing the choice is the ability to attain the required numbers of signatures in order to register for with the IEC. The chief complaint of the OSA is that the Amendment Act requires both political parties and independent candidates to acquire the same number of signatures in order to register. And so the court will see from there that the chief complaint as identified is parity of approach in relation to the signature requirement. The second point, members of the court, is if you'd look at page 42, paragraph 131, where they identify what the statutory requirement is, as it's said, and then at 132, they do the exercise as to what the real numbers in effect of that quota translates into. And then the court will go over the page 44, and the court will see that the third strand of the argument is the shifting away from the 1,000 signatures historically. And the point is made at paragraph 135 that the only, and here's the important part, reasonable inference to draw is that the 1,000 signatures satisfied the same purpose, so that political parties are serious about entering the election race. And so the focus at 135 and 136 is about the historical position as compared to the current position. And then if the court would move forward to page 48, paragraph 146. And there the court will see that the challenge is that the approach adopted leads to an exorbitant number of signatures being required, and that the principle is out of kilter with the rest of the electoral system. The previous 1,000 signature requirements had no link to the vote threshold, and nor was it linked to the number of votes per province. And it represented an ordinary, feasible, and reasonable measure. So, Justices, the point of that exercise, and I apologize for having done it, but the point of that exercise is to demonstrate that the founding affidavit does not make out the case that says the probable consequence of the signature threshold is that independent candidates will not be able to stand for election even if they act reasonably in pursuit of that right. And the court would then no doubt engage me as to what then would have been incumbent on an applicant to say in vindication of that threshold. And we submit, Justices, that what ought to have been said is that it can run up to between 10,000 to 14,000 signatures. This is what would be required in order to meet the signature requirement. Independent candidates have this kind of infrastructure available to them. This is the resource constraints, or these are the resource expectations: to put up posters, to call town hall meetings, to have people come into a town hall or wherever it is and submit or meet with the signature requirement. It cannot be done because of the cost considerations, because of the capacity considerations, because of a host of other barriers that stand in the way of the independent candidate. And the consequence of that is that the threshold creates an impermissible barrier to the exercise of the right. And that, Justices, had that been the case as made out, the answer to that case would have been a very different one than what the court sees in these papers. And none of this is intended to suggest that the answer would have been to give this court a scientific basis or premise for the 15% threshold. That, I say up front, doesn't exist, and even if the challenge had been brought differently, it would not have been done, because that's not what served before Parliament. But it would have brought before this court a far more informed basis on which one engages with these issues. It also would have elicited from the IEC, in all probability, input as to what the nature of the prescribed form and processes would be. For instance, to what extent do electronic signatures meet the requirement if they are to be adopted? What are the other avenues that would be looked at? And that would be the overall basis on which the court would be able to engage the question of where an independent candidate acts reasonably in pursuit of a right, it is nevertheless barriered from meeting it. And because the challenge wasn't brought in those terms, and nor was it answered in those terms, none of that evidence is before this court. And so, to conclude, Justices, on the first leg of the constitutional inquiry, the rights infringement, the submission is that the high watermark of what the founding affidavit says is that it's an exorbitant number of signatures, it's a departure from the historic position, and there's no parity, and there is parity with political parties. None of those allegations demonstrate the infringement that is now being advocated before this court. And we submit, if there is no infringement, then that ought to be the end of this inquiry. The court doesn't even get into the limitations inquiry. But if the court is not with me on that primary submission, then of course the question is, has the state put up sufficient evidence in order to establish a reasonable and justifiable limitation in this matter? And Justices, we say it has. And we say so for the reasons set out in our heads of argument, but I'm going to emphasize perhaps just a few. The first is the common cause purpose of the provision. I've taken the court through to paragraphs 133 and 134 of the founding affidavit. There's no dispute around that. It serves a legitimate government objective, is the submission. And it has consequences for other rights, the right to free and fair elections as a result of it. So we submit that the purpose inquiry and the limitation is of fundamental importance to this court's analysis. The second, Justices, is the inherent risk of this court of this matter being incorrectly determined. For instance, if the court were to say 15% isn't appropriate, but 1,000 signatures is, the risk is, on the evidence before this court, is that it threatens the right to free and fair elections. And that ought to weigh heavily with this court in the limitations analysis. The third point, Justices, is the 1/6 requirement. And at its simplest, and it's a complicated point, this, because I understand the questions or perhaps the submissions on the other side, but for the state respondents, the point is this. If a candidate is unable to show 1/6 of the support in order to gain a seat, what is the extent of any prejudice or rights infringement given the legitimate government objective sought to be advanced by it? And the next question we submit, Justices, in the limitation inquiry is perhaps one of the most controversial in this matter, and that is, what is the threshold that the state needs to meet in order to demonstrate that there was a reasonable basis for the computation of a 15% threshold? And there were a range of submissions that were made in the course of yesterday and in the heads of argument. And underpinning all of those submissions was a central proposition. It was this: there ought to have been a clear-cut and principled basis on which the state actually Parliament reached the 15% threshold. And in our learned friends' heads of argument at paragraph 17, they say it was incumbent on the state, paragraph 70, my apologies, it was incumbent on the state to explain how many independent candidates are likely to contest the elections and how many of them might be frivolous. So one then pauses and asks, even if government or Parliament had done more than the 7 legal opinions it acquired, than the expert analysis that it acquired, than the substantive submissions that it heard from members of the public, would it ever be in a position to meet the threshold that the OSA intends to impose on it? i.e. to be able to make a call in anticipation in circumstances where independent candidates are voting for the first time as to how many of them will be voting and how many of them are likely to be frivolous. We submit, Justices, that that is just a step too far. There's not only is there no basis for it, but I would submit that it runs entirely against the principle that this court set out in the Necro judgment referred to in our heads of argument. And that principle, Justices, was to say that a legislative choice, we refer to it in our heads at page 34, paragraph 67.1, and this court said there, a legislative choice is not always subject to courtroom fact-finding and may be based on reasonable inferences unsupported by empirical data. It then went on about, in a policy context, what the requirement would be, and it says at the end of that paragraph, if the concerns are of sufficient importance, the risks associated with them sufficiently high, and there is a sufficient connection between the means and ends, that may be enough to justify the action taken to address them. And so we would submit that on that broader basis, i.e. no scientific basis, research analysis, any of that, on that broader basis, this court will engage the information that has been put up or the evidence that's been put up by the state respondents. And importantly, in the IEC's affidavit, the court need not go there, but it's at page 523, paragraphs 25 to 27. There are a few important and uncontested averments made in that regard. The first is that there is a clear trend of a continuing increase in participating parties with a rapid rise in the last election. The second is that at the same time, there's a continuing increase in the number of parties not gaining representation and forfeiting their deposit. According to the IEC, the trend indicates that the signature requirement for the registration of a party, even when increased to 1,000 signatures, does not serve as an indicator of voter support to justify a serious contender in the elections. Then refers to the 3/4 who didn't make that threshold in the last election. And so, members of the court, we say, in light of that threshold, which is relevant to the limitations inquiry, the evidence before this court, as set out by all of the state respondents and referred to in our heads of argument, but in particular those statements from the IEC, are sufficient to demonstrate what was relied on. Members of the court, the last leg of the inquiry for a limitation inquiry is a particularly trying one in the context of this matter, because this court will be asked whether there are less restrictive means that serve the same objective as the 15% threshold requirement. And in light of all of the limitations I've spoken to already, which is that it's the first time independents are competing in this election, it's difficult to anticipate. It may well be that one might say, well, 17% would serve the same objective, or 12% would serve the same objective, and a less restrictive means is 12%. But of course, as we refer to in our heads of argument, the question to interrogate is not simply whether or not there's a less restrictive means, but is there a less restrictive means by which the same objective may be served? And that, we submit, is a task in impossibility for Parliament to have conducted in the course of the amendment process. So, Justices, for all of those reasons, we say that if the court is to get to the limitations inquiry, Parliament has put up sufficient evidence, together with the Minister and the IEC, in order to demonstrate that it's a reasonable and justifiable limitation. But if I could move on to the last of my submissions regarding the rights inquiry, and that is, if the court's not with us on either the rights infringement or the limitations inquiry, and the court is inclined to grant some relief to the OSA in this matter, here's the critical question: what form of relief would constitute just and equitable relief in accordance with what this court is constrained to do? And we say that because on the evidence and on the case made out, the request is at this stage, it ought to be at 1,000 signatures. On the IEC's evidence, 1,000 signatures manifestly does not serve the legitimate government objective that sought to be advanced in this. And the difficulty is, if it's not 1,000 signatures and it's not the 15% threshold, on what basis then is this court equipped to engage in what some middle point in between those two extremes may or may not be? And we submit that for the self-same reasons that Parliament came under criticism yesterday for not having a basis on which to rely on the 15%, this court runs the risk of facing a similar difficulty in relation to it. So for all of those reasons, we submit that the interim relief as sought cannot be granted, because on the evidence, 1,000 signatures does not serve the legitimate state objective, and the court doesn't have before it sufficient information to go anywhere between that. So, Justices, for all of those reasons, we submit that the rights challenge doesn't get off the starting blocks. I'm now going to deal very briefly with the Amicus submissions. The first issue, the first premise of the Amicus submissions is that the signature requirement imposes an impermissible barrier to entry. And of course, as a submission on its own, it may look at first glance to be a very attractive one. And proceeding from there, the amicus says, well, the signature requirements have the effect of tipping the scales towards the exclusion of independence and of creating an uneven playing field. But of course, Justices, none of that is grounded in an evidential basis. So as attractive as the submission may seem, there's no evidence in order to support it. And for that reason alone, we submit that there's no, it ought not to be given any, it has no merit. The second issue is the fact that the challenge of the amicus actually telescopes only two issues. Thank you.
Yes. Did the 1,000 signatures serve the same purpose when it was required of political parties?
I'm sorry?
Did it serve the purpose for which it had been
No,
prescribed?
it didn't, Chief Justice. There's a registration threshold and there's a contestation threshold, as has been explained. The registration threshold was founded on the 1,000 signatures, but that, of course, is not aimed at vindicating the government purpose sought to be achieved by the 15% threshold. So they served entirely different purposes. The IEC describes them as being complementary, but they're certainly not the same, Chief Justice.
Just deal with the different purposes, please.
I'm sorry?
Just deal with the different purposes.
The different purposes between them, yes. So according to the evidence, Chief Justice, the registration requirements are more, serve more towards looking at the candidate's seriousness to run for election. That's also a purpose that's served by the contestation requirements, but the contestation requirements on the 15% are aimed at ensuring a manageability of a ballot, that it doesn't run to 300 pages, that the print on it is not too small, that it compromises. So it's broader issues around free and fair elections and broader issues around the manageability of the ballot. And that's why the 1,000 signatures wouldn't serve that purpose, Chief Justice.
I don't understand you. I'm sorry. Just explain it. I really don't. I'll tell you why I don't understand it. If the 1,000 signatures was suitable back then, and the elections were run without any glitches, so to speak, and one would wonder why now are we saying the 1,000 signatures would be inadequate. And added to that is an allied question relating to the 15% ratio. I would want to know what informed Parliament from cascading downwards from 50 to 15.
Yes.
There seemed not to have been any evidence except that investigations or expertise was sought. Yes. But when I look at the papers, which I did last night again, I could not see any concrete evidence that justifies the 15%.
Yes.
Would you be able to assist?
Yes, I would. Thank you, Justice Matupu. So on 2 points. The first is, to the extent that I wasn't clear enough, Justice Matupu, the registration requirement is, of course, aimed at ensuring that the candidates who come through to contest the elections, to register as contesting parties for the elections, are serious about contesting the elections. But of course, that serves one purpose. On the evidence, the IEC says, at even 1,000 signatures, what it means is that we have many, many parties who get through the gates in order to register, but they ultimately don't get a seat in Parliament. And so that's the purpose sought. But of course, once one puts it at 15% of the threshold, the purpose of the contestation requirement being at 15% is that even if you are able to register as a party or as a party to participate in the elections, you still need to meet the higher requirement to contest the elections. Because if you don't, you run the risk of everybody, even with minimal support, not being able to, contesting the elections, very long ballot, complicated, difficult for voters to understand all of the reasons that the IEC has given on that front. So that's the difference between them, and as the IEC says, they are complementary in many ways. Justice Matopo, as regards your second question, it is correct that there's no magic in relation to the 15% requirement. As I read it overall, it started with a suggestion that this ought to be determined by the IEC. There was then a shift from that to say, let's make it at 50%. All of the public hearings raised various concerns that 50% was too high, and it then cascaded downwards. There was then an opinion sought from Council which said 20% is likely to meet the constitutional threshold, and Parliament suggested or ultimately adopted 15%. So again, I say no perfect science to it, but it was the result of democracy at work and Parliament having heard the concerns around it.
Sorry. Now we have the independent candidates helped or assisted by the applicants in this matter. If they ask, just move away from this case, and they just ask quite rhetorically, we are now required to have 1,000, and we don't, or 15%. We don't know why, and they have protested or written to Parliament to say, please tell us why now are we required to comply with the 15% ratio.
Yes.
And what do we say?
Yes.
What did Parliament say? Nothing. And what do we say as a court? Do we say, Parliament, you were right? Or what do we say?
Yes.
They need answers, I guess.
Yes. Just
Before you answer, I just want to say this because it's in line with that too. So as you answer Justice Matopo, you can deal with all of them. This is not a case where it's the first time that registration signature requirement is being prescribed. There was one for political parties. The question would be, if for political parties the requirement was A, but once now there are independents coming to the picture, you put another requirement, and this is a big jump from 1,000 to 50, to 4,000, it's going to be 4,000 or whatever. I think the IEC has even got bigger numbers, if I'm not mistaken, if it's 15%. Shouldn't this court expect that Parliament is going to be able to say that requirement which we had put for political parties didn't serve the purpose that it had been put down for? That's why we are now changing. And if it doesn't say that, shouldn't one look at this change with a little bit of some suspicion?
Yes.
To say, if this requirement of 1,000 signatures was good enough for political parties, why are you making it so hard now? when they are independent candidates. But answer Justice Matopo's question, and as you answer it, have at the back of your mind what I've just said.
Thank you very much, Chief Justice. Justice Matopo, on the question of, I do believe that it's a valid question that the independent candidates would be asking if they say, well, what was the basis on which the 15% was reached? The complexity of the question, however, becomes more apparent from the answer to it. And the answer would be, well, what could be the basis of choosing 15% or of choosing 10%? How would Parliament know in anticipation of an election that for the first time is going to include independent candidates, and for the first time it's going to be using this Amendment Act? And so how would one then be able to, and I don't mean to ask it rhetorically, but the point is that it's a task almost resting in impossibility, because it would have to mean, well, we've reached 15% because we anticipate 20,000 independent candidates putting themselves forward for it. We anticipate that 50% of that figure is going to be frivolous. We anticipate that on that analysis, we're going to have a ballot that runs into 200 pages. And so the difficulty in the question as to what then is the precise premise for the 15% is underscored by what the answer to that would be, Justice Matopo. And I would submit to the court that that answer is one that's an impossible one to give at this stage. Yesterday, there was much that was said about a study needing to be done, about this needing to be engaged on with the experts, etc. But it really does come down to the question of how does one anticipate this? And I would submit that in those circumstances, it's very difficult. And what the court's then left with is the evidence that the parties have given, and to the Chief Justice's question in relation to the shift from the 1,000 signatures to the 15%, there are two answers to that. The first is the 1,000 signatures served a different purpose, and therefore it cannot be used as the basis on which to measure the reasonableness or otherwise of the contestation requirement. But the second is the evidence that the IEC itself gives at page 523, paragraph 27, where they say even when increased to 1,000 signatures, it didn't actually serve as an indicator of voter support. So on the IEC's evidence, it doesn't meet the objective that's sought to be vindicated about. When one reads that, Chief Justice, together with the trends as distilled by the IEC, the submission is, in response to Justice Matopo, it may not be a scientific premise for the 15%, but it's based on relevant facts and material as put up by a specialist body equipped to do so on it. Thank you.
Ms. Pillay?
Yeah.
Ms. Pillay, I just want to follow up on the question. Previously, you had a political party would have to produce 1,000 signatures just to register as a political party with the IEC.
Yes.
Is it correct that there was no requirement to provide signatures to contest the actual election?
That is so, Justice.
That was the position.
That is so.
So you just become a political party registered with the IEC, then you can go and contest the elections.
Yes.
So now there's a new requirement
Yes.
that has been put in place,
That is so.
this 15%. And then what then would be, the applicants, they said they wanted to have 1,000 signatures. So what are you saying about that as opposed to the 15%?
Yes, yes. So, Justice Matlanta, let me answer it this way. The first is to say that this 15%, the 1,000 signatures served a different purpose. All a political party needed to do was to register in order to participate in the elections. the playing fields have been changed remarkably through this amendment. What we now have are the 332 plus political parties, and we have an unknown number of independent candidates. There has to be some measure of ensuring that there's a threshold in order to contest an election. Because if there isn't a threshold, then the risk is that you have a ballot that runs to 200 pages. And so you can have, and that then brings us to, well, should that threshold be at 1,000 signatures? Should it be at 15%? Or should it be somewhere in between? And to that, Justice Matlantla, the evidence is 1,000 signatures would not serve the purpose of a contestation requirement.
But so now there is basically a shift from 0% because there was nothing for political parties. They only had to register as political parties with the IEC.
Yes.
Then they would just have to proceed to the for the voting
Yes.
aspect.
Yes.
So it's now 0 for political parties to 15%. And for an independent candidate who would not be required to register, all of a sudden there's this huge jump or leap
Yes.
to 15%.
Yes, so let me just qualify that, Justice Matlantla. The first is that, of course, this applies only to political parties that are unrepresented.
Yes,
So it's not all
yes.
political parties. And the second is, of course, the purpose is a very different one in light of the number of contesting parties and or individuals that we have. And so the submission is a 1,000 signature threshold that was used for a different purpose in a different climate, where at best we had 331 parties contesting and we had registration requirements in relation to that, was very different and did not meet the current needs of the amendment as adopted. So we submit that the 1,000 signatures can't be used as the benchmark against which to measure the reasonableness or otherwise of the 15% threshold.
Now, just one last question on the submissions by the Amicus, which said that this is an onerous burden on the independents. Is there any funding that is provided to the independent candidates?
I'm sorry, I missed the first part of the question.
Yeah, submissions by the Amicus that this is an onerous burden on the independent candidates who don't have funding and resources.
Yes.
Is there any funding that is provided for
No.
independent candidates?
Yes, Justice Matlantla, I grappled hard and long with that submission, and I looked carefully at the evidence in relation to it. And the submission I make in response is, if the case as brought was to have said, these are the likely cost implications of a 15% threshold. These are the expense limitations that independent candidates have as compared to political parties who are unrepresented, because that's the comparator on here. And this is why it's unreasonable. Then it may well have been a very different debate that we'd be having. But we don't have that on the evidence. And so unfortunately, there's no engagement around that. And there is reference in the heads of argument to resource constraints, etc. And I think one can broadly accept that independent candidates present from a different premise than political parties do. But even that isn't a one-size-fits-all basis. There are different kinds of independent candidates who come in at it with different measures of support, etc. And those would be the kinds of issues that ought to be interrogated in an application if that was the ultimate objection, that it's an unlawful, impermissible barrier because the threshold is incapable of being met even if we take reasonable measures in pursuit of it. Thank you.
The Deputy Chief Justice has questions for you.
Thank you. Thank you, Deputy Chief Justice.
I just have one at this stage, Ms. Pillay. On the question of remedy, now, I just want to find out from you, because you've said the interim relief is a no-no. If we find for OSA, what good would the relief they seek
Yes, yes.
Without interim relief, what good would it do them?
Yes. So of course, that is precisely the difficulty that this court is presented with, because, of course, as we know, this court's jurisprudence says that it ought to be granting remedies that can effectively vindicate the rights. And the difficulty in that, in relation to the interim relief, is that if I've already made the submission that it can't be pegged at 1,000 signatures in light of the evidence that has been put up. The question then becomes, how does this court determine what is just and equitable on some figure in between 1,000 signatures and 15%? And never mind the highly intrusive nature of an order in those terms, given the wide remit given to Parliament in respect of electoral laws, etc. But the court would be doing so on a double disadvantage, because the second disadvantage is it doesn't have the evidence on which to premise it. So at best, what this court would be doing is something that's no different from what Parliament's been done, which is to say, well, we don't think 15% is appropriate. We don't know what the magic figure is, but let's bring it down by 5% or by 7% or whatever. And it would be then a random exercise, I would submit, and I would submit that in doing so, this court would not have met the imperatives of granting a just and equitable order. So, Deputy Chief Justice, it doesn't answer the question, or perhaps I must accept that that answer doesn't give effective relief for the purposes of the 2024 election. But there's no other way that it's one of those unusual and perhaps exceptional cases where the submission is that to do otherwise would run against this court's jurisprudence.
Well, it would not be a random thumbsuck to try and find a balance. We have 1,000 signatures, which the other side say, works for the reasons they advance, that
Yes, yes. Deputy Chief Justice, the difficulty with that is the first hurdle for this court is for it to say, notwithstanding the different purposes to be served by the 1,000 signatures and the 15% threshold, and notwithstanding the evidence of the parties that 1,000 signatures does not suffice. The court would have to say, in spite of that, I can't tell you on what exact basis I'm reaching a 5% threshold, but I'm going to do it because it's less onerous than a 15%. And the risk of doing that is that it's being done in circumstances where an urgent application is being brought, where the court is stepping in, and where the consequence, where this court doesn't know, it may well be, well, at 5% we're going to be landed with a 100-page ballot on it. And so those are some of the difficulties around engaging on remedy, Deputy Chief Justice.
Justice Theron.
Thank you, Justice.
Thank you, Chief Justice. To pursue the line of questions of the Deputy Chief Justice, perhaps I was going to say I'm thinking on my feet, but I'm actually sitting. If I understood your argument, there's two requirements, the registration requirement and the contestation requirement. Now, it looks as though Parliament has collapsed the registration requirement and is now only dealing with the contestation requirements. Is that right?
No, so you still, for political parties, you still have the registration requirement in respect of the 1,000 signatures. Okay, there is a difference. Mr. Budlander says that he will deal with it in more detail, but in answer to your question, there remains a registration requirement for political parties, and that is at 1,000 signatures. The contestation, which applies to both, is at 15%.
Is there a registration requirement for independent candidates?
There is none.
That's my difficulty. So we had, if I'm following the two requirements, we had one, now we have two.
Yes.
In respect of remedy, and it might be difficult for you to agree to this, would it be possible for this court, without overstepping the realm of separation of powers, to say that we have a registration requirement, we have an existing registration requirement. That requirement, which applies to political parties, should apply to independent candidates as well. In respect of the second requirement, of the contestation requirement, perhaps Parliament hasn't done enough to show that that passes constitutional muster and send that requirement back.
Yes.
What would you,
Yeah.
will that be an option that's open to this court?
It wouldn't for a multitude of reasons, Justice Turan. Let me start by saying the following. From an evidential basis, we know that it's common cause that there's a legitimate government purpose to be served by a contestation requirement. The effect of an order in the terms that you've proposed would be, notwithstanding the common cause evidence on that point, the court would be striking a line through it. And I would submit that that would be an overreach on separation of powers in the most fundamental way.
But there are please continue. I'm sorry to interrupt you.
Not at all. The second one is this. There is no challenge before this court around the differential registration requirements. And had that been challenged, the evidence before this court may well have been very different. The evidence may have been to say, well, we don't have a registration requirement in relation to independent candidates because we want to make it easier for them to go, so they don't have to get through the first gate or the first threshold on it. Notwithstanding the absence of evidence on that, on the proposal made, the court would be effectively collapsing two disparate requirements that serve different purposes in circumstances where there's no evidential basis to do so.
So, once again, if I understand your argument, the registration requirement serves the purpose of showing that a candidate is serious.
Yes.
The contestation requirement goes to the manageability of the elections.
Correct.
Now, I have two questions for that.
Yes. And I'm sorry, before you, to the extent I might have been heard to agree entirely, the contestation requirement in the main is around the manageability of the election, but it also serves to ensure that there's no frivolous candidates in it. Subject to that, that's correct.
Yes. So, this court could say it's satisfied that the purpose served by the registration requirement has been proved to be valid, and that passes constitutional muster. But in respect of the contestation requirement in making the elections more manageable, it hasn't been shown that it would be impossible. It's just been shown that it would be difficult. And that was a question that also came up in the last matter when we dealt with the case of whether the election should be postponed due to COVID. And I think that was a serious concern and perhaps the turning point in this court's judgment in that matter.
Yes. So, Justice Turan, the difficulty, of course, with that is one has to ask, in granting a just and equitable order, this court will obviously want to ensure that orders are capable of being given practical effect to. And on the proposed order that you've put to me, the difficulty with it is, well, if the threshold is impossibility in relation to this, what then would be the nature of the evidence that Parliament would have to put forward next time round on this? And I would submit, with respect, Justice Turan, Parliament would be in no better a position next time round. If anything, this would be a precursor to showing that that threshold of impossibility would certainly not be capable of being met.
Now, perhaps I've missed part of your argument, but what informed Parliament's decision to collapse the registration requirement in respect of independent candidates and move directly to a contestation requirement? And let me just add on to that. Would it be possible initially to have a registration requirement and at some stage down the line, before elections are held, have a contestation requirement, whereas you don't eliminate parties right from the beginning, or candidates from the beginning?
So, Justice Turan, the first part of your question about what actually resulted in a collapse of the requirements, that's not the challenge that was brought. And so there's nothing as engaging with the detail of the separate requirements. The points are made, but there's no, because as we understand it, there's no challenge to the registration requirements in respect of political parties. So that's not the subject of any engagement around it. And so then and it brings me back, I'm fearful of repeating myself, but it brings me back to my answer to an earlier question that you posed, which is to say that the caution around that would be that it cuts across certain provisions that are not the subject of attack in this litigation and that are not the subject of the evidence that has been given in this litigation. And so for that reason alone, the submission is that it wouldn't be just and equitable.
Now, the contestation requirement might be a legitimate concern of both Parliament and the IEC, but is that the constitutional test that this court must apply in terms of whether the elections will be manageable or not?
Yes. So, Justice Turan, the answer to that, of course, is premised on what is the constitutional issue that this court is being asked to rule on. And if the constitutional issue is that which I have articulated, an infringement of Section 19 rights to vote and stand for election, then the first question is, well, on what basis can it be said that a 15% threshold results in an infringement of that right? And then, of course, the court will then go through the analysis as I've described, and it would reach then the limitations inquiry. The limitations inquiry would not be relegated simply to a question of, well, it was parliamentary preference at the end of the day. But it would be there's a legitimate purpose to be served. There's no information in anticipation that we can look at now. There's the trends as we have it. There's the difficulty of identifying the less restrictive means, and it would be the cumulative impetus of all of those factors as part of a Section 36 inquiry that would ultimately carry the day, Justice Turan.
Yes. Now, my last question, Ms. Pillay. We heard argument yesterday, and we were referred to the opinion of counsel.
Yes.
I think which said that 15% threshold was too high, and it's too high a barrier for independent candidates to cross.
Yes.
What does the court make
Yes.
with those submissions?
Yes. So, Justice Turan, there are a couple of points around there, and they seem to have been conflated. The first issue was that counsel was advising on an appropriate percentage basis around it. In the opinion, which I think it was the one of the 26th of September, in the opinion, it was the advice was in relation to a 30% threshold. If it resulted in 14,600 would be too high. Justice Turan, you then see that there were later opinions which dealt, and there's a back and forth on the papers as to the correctness or otherwise of figures, etc. But ultimately, what counsel advised is that 20% would actually pass the threshold. And in fact, Parliament went on a more cautious approach than that of even what eminent counsel advised it, and it went for 15%.
Thank you, Ms. Pillay.
Thank you.
Thank you, Chief Justice.
Justice Colopin.
Thank you, Ms. Pillay. Just on that point, 30% would be too high.
Yes.
But that was 30% of 44,000,
That's
correct? And 44,000 was a quota for a seat in the National Assembly, correct? 44,000 was not a quota, was not a regional quota.
Yes.
The opinions seem to have pegged the percentage on 44,000 consistently. The last opinion says the regional quota could be higher.
Yes.
But we need not speculate whether it could be higher.
Yes.
Because as we sit here, those quotas are known.
Yes.
The regional quotas are all in the area of 80,000.
Yes.
Correct.
Yes.
And so if the calculation is 30% of 44,000 is too high, then surely 30% of 80,000 must be extremely high.
Yes.
And my concern is, I don't find with respect, the memorandum, the use of an accurate figure.
Yes.
Because Section 31B tells us that we use the regional quota.
Yes.
The regional quota would be the results of the 2019 election. Those are out and published in a matter of public information. And so you would agree with me it would be correct to use 15% of the regional quota,
Yes.
and not of any other figure.
Yes. So,
And the discussion that emerges from Mr. Chabani's affidavit and the memorandum, the high point of that is that it could be higher than 44,000. But as I put to you, we need to be able to say categorically, it is 80,000.
yes.
And then if you translate the figures, it's considerably different.
Yes.
So that's my first question.
Yes. So, Justice Cullipin, perhaps the submission is that ultimately this is a question that Parliament had to determine. It sought these opinions, or the minister sought these opinions, they were considered, etc. The ultimate advice was not on the basis of any calculations, it was simply on the basis of a percentage basis, and it was the 20% basis. And I would submit that one can't read anything from that in terms of calculations done or otherwise around it, but what it does show is that it's a consistent shifting down of what the figure was ultimately. And Justice Cullipin, in addition to that, of course, the first answer to that question is the case as brought in the founding affidavit doesn't traverse that issue.
Sure, but Ms. Pillay, ultimately it's not about percentages. Ultimately it's about the numbers a candidate must get. And therefore the percentage of what figure is critical. And to that extent, was there not a failing on the part of Parliament by simply having regard to the data that was available in saying what would this translate into what an independent candidate must get?
Yeah.
But you've responded. My second question is this, is that 44,000 is the quota for the National Assembly seat on the national tier, and 80,000 is. And so an independent candidate cannot contest a seat in the national tier, correct?
Yes, yes.
And therefore, an independent candidate does not have the luxury of a calculation based on 44,000.
Yes.
As we sit here, all the independent candidates know what their calculation must be, depending on which. And so is this not a case of sort of double jeopardy almost, that you're excluded from contesting a seat in the National Assembly for good reason, but because you're confined to contesting a seat in the regions, your percentage is considerably higher.
Yes, yes.
And the difficult question is that we could have this debate, but it doesn't appear that Parliament applied its mind at all to that distinction.
Yes.
And if it had, it may have come to a different conclusion.
Yes, yes. And Justice Cullipin, of course, one takes it further, though, and again, I don't want to belabor the point, but the issue is really the challenge that Parliament in the State's been brought in to meet on this. And I've already referred to what the founding affidavit says on this. And one can speculate around what answers would be, and we've tried as Parliament to put up as comprehensive, to the point of it becoming a little bit irritating with all of the memoranda, etc., as comprehensive a view, but I can't, as I stand here today, I can't tell you that it reflects exhaustively on all of the issues that featured in the debate.
So all I wanted to say is that the parliamentary process and the reports were undertaken and compiled long before the commencement of this litigation. It's simply a reflection of what went through that process and whether the process was closed to certain information, not deliberately, inadvertently, but nevertheless that the conclusion they reached may have been based on an incorrect foundation. Yeah.
I've made my submissions. Thank you, Justice Cullipin.
Justice Rogers.
Ms. Pillay, according to the IEC, the requirement for registration as a political party at the national level increased to proof of 1,000 voter support. in August 2021.
Yes.
Our most recent national election was 2019. Yes. So the 2019 elections were conducted on the basis of a requirement for national registration of 500. That was the previous regulations.
Yes.
That resulted in 48 parties contesting,
Yes.
and 14 of them gaining seats.
Yes.
You talk about hundreds of pages of, potentially of,
Yes.
multiple pages of a ballot.
Yes.
As I understand the IEC's evidence, on 48 contestants, which was the number of parties that contested in 2019, you can have a single ballot page comprising a list of parties in a single column. They then say if that number increases up to 96, but not more than 96, you can still have one page, but you will then have a second column.
Yes.
And that will come at, I think, in relative terms, given the importance of what we're talking about, at a relatively modest incremental cost of 13 or 14 million rand
Yes.
to have a second column. Now, what puzzles me is that when it was the IEC that set the requirement of voter support to register as a political party by way of regulations promulgated under the Electoral Commission Act.
Yes.
In August 2021, knowing what the trend was, including the results in the 2019 elections, they decided, let's increase the this was before, although this court had given its judgment in New Nation, we didn't yet have legislation governing independent candidates to contest. But knowing the entire trend, including the most recent election,
Yes.
they decided to increase the requirement for political parties from 500 to 1,000.
Yes.
They must have then thought that to have a manageable election, it would be sufficient to double the requirement that political parties needed to demonstrate. Because at that stage, there wasn't a separate contestation requirement.
Yes.
This whole idea of managing elections and this bogeyman of unmanageable ballot papers arose only because this court said, well, independent candidates must also get a shot.
Yes.
And am I right that originally the draft legislation didn't even contemplate that this, quote, this threshold, 50%, 30%, 20%, would even apply to new political parties
Yes.
at all? It was only ever intended to apply to candidates, but at a relatively late stage, and I think Council welcomed this in one of their later memorandum, said, well, that will make it look a lot fairer if unrepresented parties are on the same playing field as independent candidates.
Yes.
But of course, we know that the numbers of this quota of 15% translate to something around about 13,500 on average.
Yes.
Why did the IEC think that 1,000 was all right in the light of the trends in August 2021,
Yes.
but now thinks 13,500? Well, I say the IEC. The IEC sort of supports it in its affidavit, but it's Parliament's decision.
Yes.
Why is 13 or 14 times the requirement that was introduced only 2 years ago now thought to be necessary
Yes.
in order to make the ballot paper manageable?
Yes. Yes. So I think that perhaps two answers on that, Justice Rogers. The first is, if I can refer you to page 522 of the papers, that's the IEC's affidavit.
The paragraph number?
Paragraph 23, the end of paragraph 23, where it explains in 2021 the three-tier system was introduced with different voter support requirements for registration set at national provincial level, and then it says it then set the threshold at 1,000. And then if the court...
And that was done after they
I
knew the
accept.
trend from 1994 to 2019.
I accept that, Justice Rogers. And then if one could look at page 523, paragraph 27, where the IEC goes on to say, importantly, the trend indicates that the signature requirements for registration, even when increased to 1,000 signatures, does not serve as an indicator of voter support.
And on what election is that based?
Yes, and I accept there's no election on which that's based, but that's according to what the IEC said on that.
So on the face of it, there's no election that can support that proposition.
Yes, yes. But of course, Justice Rogers, the one point is this: even though this court's judgment may have been handed down at that point, it's these amendments, of course, pertinently grapple with impact in relation to independent candidates. And one may or may not have considered that in 2021, I'm not sure. But when you're amending, or when Parliament's amending legislation specifically in 2023 to a process that preceded it, in order to cater for independent candidates, and it reaches this conclusion, I would submit that I accept there's no election in between, but it's the IEC's view on it.
Because particularly since this threshold was initially conceived only to apply to independent candidates who have never had a chance to contest before.
Yes.
One almost gets the impression that a particularly high hurdle is being placed on independent candidates, perhaps out of some fear that the ballot paper is going to be swamped by independent candidates. I'm not sure why that belief should exist. But is it right, at the very threshold of first having independent candidates, we've got no history of them, that we should impose a contestation eligibility requirement that is so much higher than anything that has previously operated?
Yes.
We know in 2019, at 48 contesting parties, from the IEC's own papers in this matter, we know that we could have double that number and still only have one ballot page.
Yeah. Yeah.
Might be confusing for voters to have to run down their eye down two columns to find out 51's my man or woman that I want to vote for. But it's manageable.
Yes.
Why, at the very threshold, with no experience at all, should we almost, so it seems to me, be closing the door to independent candidates, except perhaps one or two very high-profile people who perhaps have left political parties and already have some following?
Yes, yes. Justice Rogers, I understand the concern at an overall level. I'm not ducking the question, but the submission is, of course, that, though, isn't the, perhaps let me put it differently, what this court needs to engage with, having now knowing that there is no rationality challenge to this debate, is whether in having placed it at 15%, it results in a rights infringement. It may well be, or it is, I can't dispute that, it is a shift from what the pre-existing position was. It is in a context of a new contestation requirement. But the ultimate question is, accepting all of that, can one say that it results in a rights infringement in the terms that it's been brought in this challenge? And the submission is, it doesn't, for reasons I've raised.
And just finally, on this point, according to the IEC, and I'm only talking at the National Assembly level, 14 parties obtained seats at the 2019 election. And those are the 14 contestants who will not have to requalify, as it were, to contest again.
Yes.
Now, assuming that a ballot paper up to 96 names is doable, it only requires one page, even if it requires 2 columns. That leaves, if we subtract the 14 existing represented parties from 96, it leaves 82 names potentially qualifying. So on this new requirement, if we're going to fill up one ballot page, 82 parties would need to each, parties or individual candidates, would need to meet this requirement. And what we don't have is anything to suggest that, I prefer to talk about raw numbers than a percentage, but say a requirement doubling the one, I don't know why 1,000 was acceptable 2 years ago but isn't acceptable now, but assuming it's not acceptable, is there anything to suggest that if for contestation you have to put up, this is before perhaps you start campaigning, this is 2 months out from polling day. You have to come up with 2,000 names.
Yes.
Are we going to find 82, more than 82 parties and individuals who will come up with that many names in order to just be entitled to have their names on the ballot paper? Do we have anything to suggest that 2,000 won't be enough?
Yes, yes. Justice
Because,
Rogers.
I mean, clearly 15%, I accept, probably will be enough, as would have been 50%.
Yes.
Any high number will be enough. The important question is, what's the lowest number that's enough?
Yes, yes. And again, I don't duck the question, but I would submit that a question like that is, of course, to be determined on what's before this court. And the difficulty on this matter is, even if one were to say, go and do it a different way next time through what can possibly be considered, one doesn't know. And the answer, Justice Rogers, may well be that the 2024 elections are going to tell a story in terms of approach, trends, independent candidates, etc. And it may well be a different picture attendant on that.
Well,
I
of course,
don't know.
If very few independent candidates could get onto the ballot paper, the 2024 elections probably won't tell us very much about independent candidates. But if you want to say, what do we know on the papers? We know on the papers that at a level to register as a political party at the national level, you needed only 500 voters to support you. We know that in 2019, that only resulted in 48 parties contesting. We know as a fact that 2 years after the 2019 election, the IEC decided that that level should be increased from 500 to 1,000.
Yes.
And we don't yet know what its effect will be.
Yes. Yes.
That's what we know. And we know that on the IEC's evidence, we could increase the number of contestation from 48 to 96 and still have a single ballot paper.
Yes. So, Justice Rogers, I'd only perhaps emphasize this point, and that is, in 2021, whatever the position may have been in relation to this court's judgment, as a matter of fact, we didn't have electoral legislation that allowed for the participation of independent candidates. We're therefore, I would submit with respect, entirely in the realm of speculation as to what informed and underpinned 1,000 signatures in circumstances where this court had handed down its judgment, but the amendment to the electoral legislation hadn't yet taken place. In circumstances where the IEC is engaging with it in direct response to the judgment of this court and in the context of the amendment, and it says on oath that the 1,000 signatures won't meet the objective, then I would submit that the inquiry it doesn't become perhaps quite as easy as to read from the effect of the 1,000 amendment in 2021. Thank you.
Mr. Skippers.
Ms. Pillay, just allied to my brother Rogers' question as to what we know on the papers. In the light of your argument that there has been no case made out of an attempt to attain the threshold which has failed because it is too high.
Yes.
Is there anything on these papers? It was put to you repeatedly what we know from the papers. Is there anything on these papers that sustains an attack on the 15% threshold, absent any evidence of any attempt to attain it?
I'm sorry, Justice Skippers. Would you mind repeating the question?
You've indicated that there is no case has been made out in the founding papers as to any attempt to attain the 15,000 signature, the 15% threshold, which has failed. Am I right?
Yes. So I've made the point slightly differently, which is if the ultimate challenge is that it imposes a barrier to Section 19 rights,
Yes.
then the case as made out ought to have been, these are the types of constraints, and this is why
Yes.
it would be impossible to comply with the threshold.
Yes, yes,
then
I
we're
follow
on the
that.
same page, Justice.
Apart from that,
Yes.
is there anything to suggest, for example, on the 500 to 1,000 signatures, the fact that there was a change in 2021, the fact that it is irrational, and I take your point that the irrational challenge has not been made,
Yes.
but is there anything else on the papers to indicate a case that there has been an infringement or a threatened infringement of the 19.3b right to stand for election?
No, nothing at all, Justice Gibbons. Thank you.
Thank you.
I don't see any further indications from my colleagues. Thank you very much.
Thank you very much, Chief Justice.
We are at
Thank you.
Thank you. We are at 25 minutes past 11. We'll take the short adjournment now, and we'll return at 22:12. The court adjourns.
Only 10 minutes. The agenda producer says to me, says it's and that was part of the production, cannot use exactly 6 until lunchtime, because there's time to collect and then it's out. And what time is lunch? I said I said I'm not doing this today. What time is lunch? I said no way, I'm being told. What time is lunch?
ladies and gentlemen, let us take our seat, please. Let us be ready.
Mr. Badlinder, your 30 minutes starts now.
Chief Justice, members of the court. Chief Justice, members of the court, in the course of this address, I will spend 2 minutes, and I hope literally 2 minutes, dealing with the recalculation challenge, and then I will spend the rest of my time on the signatures requirement. We spend so little time on the recalculation challenge because it appears almost to have been abandoned. It wasn't seriously argued, and our heads are very full. We make only 2 points. What is the recalculation challenge actually about? It is common cause between the parties that sometimes there will be a forfeiture or a vacancy. Just let me use that term broadly. It is common cause between the parties that there is a need to fill it. And it's common cause between the parties that it will have to be filled by virtue of identifying someone next on the list. All of that is common cause. The only debate is the method. The Act says that you do a recalculation, and you do the recalculation removing the votes for the relevant seat, and then, if needs be, applying something called the largest remainder formula. The applicant says you must just apply the largest remainder formula and you mustn't do a recalculation. That is the sum total. Now, with respect, there are 2 difficulties, fundamental. The first difficulty, and I will make a confession here at the risk of being regarded as the ultimate geek in this court, I actually love maths. Sometimes I think I would have enjoyed going into something more mathematical. But with respect, I didn't. And this is not a maths court. This is a court about constitutional law. And the notion that I should be debating before you whether the Constitution requires the use of the most remainder formula or the use of a quota recalculation followed by the most remainder formula, with respect, just demonstrates the problem. That is a classic nuts and bolts setting the rules. It's for Parliament to do. There's no patent problem, and as Justice Rogers put it, any problem that exists has existed since the beginning. So the problem doesn't get out of the starting blocks. But even if I'm wrong on that, there is a fatal flaw in the OSA's case on that, and it admits as much in the Atkins report. And it's the problem that we have dealt with in our heads in some detail at pages 44 and following, under the heading, "The OSA's proposed solution is itself unconstitutional." And it's a problem of what is technically called low remainders. Because when you apply their system, what you effectively do is you go and see who was next in line with the next remainder. But the problem is that that person with the next remainder might have a tiny number of votes. And so you might be filling the seat of A, which had a proper quota, with the seat by B, who had nowhere near the quota. And that can never be in accordance with proportional representation, democracy, equality, all the rest. It's a problem that the OSA's own expert report raises. We've pointed to that. It's raised at pages 165 to 166 of the record. But extraordinarily, it's not dealt with by the OSA's founding affidavit. It's not dealt with by the OSA's heads of argument, and although we devoted pages to it, it was not dealt with by our learned friend. Well, with respect, you can't come to this court and ask for a remedy which would itself be unconstitutional. And that, with respect, is the end of the recalculation debate in our submission. If there are questions, of course, I will take them in due course, but I'm not going to waste more time on that. Can I now turn to deal with the signatures issue, which the court has debated backwards and forwards? And I'd like to step back, if I may. And I'd like to test the proposition by speaking about a hypothetical candidate who was mentioned in court yesterday. And the hypothetical candidate mentioned by himself is Mr. Rogers. Because in the course of the debate, Justice Rogers put the point, and it was a penetrating point. It said, well, I'm not sure I know 3,000 people. How am I going to secure 14,000 signatures? And I accept that if your name is Mr. Rogers or Mr. Budlander, let me be clear, the prospect of securing 14,000 signatures seems daunting beyond all measure. But now let me ask the question this way. How much more daunting is the prospect of Mr. Rogers or Mr. Budlander or Mr. De Beer securing the 92,600 votes that would be necessary to obtain that seat? Because when we speak in absolute terms about the numbers, 14,000 seems very high. 14,000 is only 15% of what was required to get a seat in Gauteng in the last election. So you need 14,000 seats, 14,000 signatures to get onto the ballot, but that means you need 92,600 votes to win a seat. So I ask, and Justice Skipper's raised it, and it's a point made, and it's never, ever been answered. Why on earth is there a disconnect, constitutionally speaking, between a requirement which says we know what you are likely to need to get a seat? It's 100%, it's 92,600. We set a quota at 1/6 of that. How is that an unreasonable, disproportionate prohibition? And when you read these papers, there is no answer. And so when Justice Skippers puts to my learned friend, well, isn't it true that there is no evidence that anyone tried to get these signatures? Because, of course, they could have been collecting signatures or at least lining them up. There's no evidence that anyone tried to collect these signatures and failed or had any difficulty. There's no evidence even to say, this is what I would envisage in doing in collecting the signatures, and I don't think I'll be able to because it's too expensive, too costly, too time. There's nothing, not a word. But there is also no word on the second problem, which is, I don't think I will be able to get 14,000 signatures because it's too costly, too timely, too expensive. But I'm confident that I have a prospect, any prospect, of getting 92,600 votes. Now, without those two pieces of evidence, this challenge is stillborn. And what this court could do, with respect, is not decide this case forever and a day. Not decide the case in a way that it says this is Justice Matopo, I think it was, I might have it wrong, who said, are we meant to say that Parliament's decision was correct? No. What this court should do is say that in this case, there is no proper evidentiary basis made out for this challenge, and the challenge is dismissed. And what that will allow is that it will allow the elections to take place. We will see whether the signature requirement is really as high as everyone maintains. We will have an independent electoral advisory panel which will advise the minister on how, and Parliament on how to fix this if it is a problem. And if it does, and if it is, and if one, if it is a problem, and two, if the problem is not fixed, then a proper challenge can be brought on properly prepared papers, which says, I am Mr. Smith. I wanted to run as an independent in 2024. I was unable to do so because despite doing A, B, and C, I couldn't reach 14,000, and I'm confident I would have obtained 92,600 votes, and let me explain why. So this court is not, if it dismisses the challenge, deciding that this is constitutionally impenetrable, constitutionally compliant. It can do it on a much narrower basis. There is no evidentiary basis made out for a challenge to this provision. The case is therefore dismissed, finished. And what that does is it enables the court to do what it ought to do, which is apply judicial restraint and not to strike down provisions unless it has had a proper case made out. Because what we're asking for is not some radical proposition. The proposition is you say this, because remember, the applicants are independent candidates. It's not Freedom Under Law or the Open Society Foundation. These are the people who say, I want to contest the elections. And they put no evidence at all to say, I will be unable to. Not one affidavit from someone saying, I will be unable to for this reason. And so what this court should do is what it did in Savoy, in a very different context. In Savoy versus the NDPP, it said, where you bring a facial challenge, which is where we are, where you bring a facial abstract challenge, you have a very high bar to overcome. And so what the court did in Savoy is it dismissed the challenge, but it made clear that in due course a further challenge could possibly be brought on the basis of properly prepared papers, proper evidence, and the experience of the 2024 elections. And we submit that's the appropriate response. But before I move on to the submissions, I want to contrast the example of candidate Budlander, candidate Rogers, or candidate De Beer with a different candidate. Because the notion of me knowing 14,000 people is it's distant, let me say. But for those who are in the social media world, 14,000 is nothing. And if you think about, when you think about who are independent candidates likely to be, and I have no inside knowledge, I'm only judging by what the chattering classes say, one thinks of someone like Thuli Madonsela. Well, when you go and look at Thuli Madonsela, I'd like to ask you how many Twitter followers Thuli Madonsela has. The answer is 1.7 million. When you think about candidates like Zaki Ahmad, who has announced that he is running as an independent candidate, he has a Twitter page which is devoted to that, and he has 40,000 Twitter followers. So now, of course, I'm not trying to say that means it's possible. I'm not giving evidence. But what I'm saying is when the court asks, as Justice Rogers fairly asked, can we deal with it as a matter of common sense? The answer is up to a point. But common sense is not viewed from a judge's chambers or from an advocate's chambers. One has to have regard to the fact that in 1 million people at the click of a button, that's very different, with respect, from the old style of putting up posters on lampposts and hoping 14,000 people drive past. And if the case had been properly made out, if they had come to court and said, we cannot do it because of A, B, and C, that is what the answering affidavits would have said. They would have said, but you don't have to put up posters on lampposts. What you have to do is do all the rest of those things. And so the case needs to be viewed in its proper realistic context and in its proper evidentiary context. Against that backdrop, can I turn to deal with the following issues? Firstly, I need to spend a moment on the two requirements, the registration requirement and the contestation requirement. Then I need to spend a moment on the Venice Commission, and then I need to spend a moment on the test, the test and the question of remedy. Now, on the first question, the two requirements, questions were asked in answer to my learned friend about the difference between the registration requirement and the contestation requirement. We have a slightly different read from her. We understand that they are different and that they serve somewhat different purposes. The registration requirement still exists in our law. In answer to Justice Theron's question, it has not been collapsed. It still exists in our law, and it exists in sections 15 and 17 of the Electoral Commission Act, read with the regulations for the registration of political parties. Now, when you go and read those regulations, what they say is that to register a political party, you have to do certain things. You have to produce a constitution, you have to have your logo, and you've got to have 1,000 signatures. Used to be 500, it's 1,000 signatures. Now, what is the purpose of that? before all these amendments. The purpose of that was not merely to allow you to contest the elections, it was also to enable you to protect your logo, name, and identity as a political party. And you see that from 8C of the regulations, which makes that clear, which says that where you are registered as a political party, you are entitled to protect your name and logo, etc. And so the idea of registration of a political party is almost the equivalent of a trademark. It enables me to go and say, I am starting the United Cricket Party. And when I start the United Cricket Party, no one else can come along and there are regulations which say this. No one else can come along and use my logo. No one else can register a political party in my name. No one else can purport to be me. And you can understand how important that is, particularly if I'm going to start campaigning. So the registration process is not so much about contestation. It was about the protection of political parties and, allied to that, making sure that the only political parties who registered were those who subscribed to the ideals of the Constitution. Because when you go and read those regulations, you will see you can't register a party that is racially exclusive. And there have been debates about whether Black Land, Black First could be registered, etc. So the registration provisions are not about contestation in that way. They are about a different legitimate purpose. And that explains, Justice Theron, why it doesn't apply to individuals. Because I don't need to register my name, Stephen Budlander, as an equivalent of a patent or a trademark. It is my name. I am the only one. And nobody else can claim to be me. And if they did, they would be subject to action. But I don't have to register because I don't need to have that protection of a logo and of a name, etc. So that's the registration requirements. The contestation requirements are different. The contestation requirements are those which have been introduced now, and they've been introduced in the two provisions which we know, and they are separate. They've been introduced in 27(2)(CB) for political parties and 31(b)(3)(a) for independent candidates of the Electoral Act. Now, why were they introduced? Because there has been a suspicion that this is somehow an effort by political parties to shut down independence or shut down competition. But with respect, that is not a fair reading of the history, because if you go to the Valley Musa report, that was the report proposed, that was the report of the experts appointed by the minister, and you see it in the papers, this requirement of a signature requirement, not the 15%, but the requirement of a signature requirement, appears in the Valley Musa report at pages 303 and 309. It appeared for both the minimalist and the maximalist option. And at 303, the Valley Musa report said, this option suggests the following criteria, qualification criteria. There's a residential qualification criteria. B, proof of sufficient voter support requirement for independent and unrepresented political movement parties to manage the risk of too many names of parties on the ballots. C, satisfaction of legal requirements and proof of sufficient voter requirement for political parties not elected. So this was not something dreamt up by Parliament in an effort to ward off competition. It was proposed by the very independent committee that was designed to allow independents to run. Now you might ask, and the question is, well, what is the fear? Why is it that independents are different? And the answer, and I'm sorry to say it, it's a result of human existence, is human vanity. One has to say that there are many people in our society who have the means and the vanity to pay the 20,000 Rand which is required, because the IEC tells you that's all that's required, to pay the 20,000 Rand required just so that they can tell their friends and their compatriots, look at me, I'm running for election. I'm going to show this government what's what. Now, I don't know if you know people like that. I know many people like that. But it doesn't help anybody if they are people who only know 1,500 people and are never going to raise the 92,600 votes. All it does is lengthen and complexify the ballot paper. That's all it does. And so for that reason, the Valley Musa report proposes a proof of sufficient voter requirements. I accept it doesn't say whether it's 15%, 10% or 5%. That is the matter Parliament can, and I'll come to that. But that this is a legitimate and important purpose is demonstrated by the Valley Musa report. So now we come to the nub of the debate, which is this an appropriate figure? And when I say appropriate, I use the word deliberately, because I go back to the submissions of yesterday, if anyone can remember that long ago, which is that this is an area where Parliament needs to be given some deference, where there is a range of reasonable options. And the there's only one benchmark which has been put up in this case to suggest what an appropriate figure is. Only one. It wasn't put up by us. It was put up by Ravonia Circle. And that is the report from the Venice Commission. Now, I would ask the court, apparently the Venice Commission report is not actually before the court in its entirety, it's just quoted. I'm sure that the clerks will find it for the judges, it's not difficult. But if you read the Venice Commission report, start with the beginning, because the Venice Commission is trying, it says, we are trying to research elections throughout Europe, we're trying to do this, and we're doing a code, and it says, the code is based on the underlying principles of Europe's electoral heritage. Lastly and above all, they constitute the core of a code of good practice in electoral matters. So the Venice Commission, and of course, having worked here, I know that this court knows the Venice Commission well. The Venice Commission tries to distill constitutional principles for the benefit of guidance of other countries. Now, it's true that it originates in Europe, but how suddenly the Europe is no longer a decent comparator for us is beyond me. Europe consists of a range of different countries and a range of different systems, and this is what they have come up with. And what do they tell us? 1.3 says, submission of candidatures. 1.3.1, the presentation of individual candidates or lists of candidates may be made conditional on the collection of a minimum number of signatures. Legitimate purpose. 1.3.2, the law should not require the collection of the signatures of more than 1% of voters in the constituency concerned. So not 1% of the quota, 1% of the voters. Now, Ravonia Circle puts that up with a flourish in its Amicus application to say, you see, you're 15 times worse than the Venice Commission. But when they go and read the report carefully in light of our heads, it's clear that it's a defense of the state. Because I would ask you, members of the court, to have regard to the, and I know there's been some toing and froing, but the final figures put up by the IEC, that was the supplementary affidavit put up on Monday, but nothing turns on the differences. There were just some typographical errors. I'm going to read you the percentages of registered voters required in each province. So remember, the Venice Commission says not more than 1%. The Eastern Cape, 0.36%. Free State, 0.81%. Gauteng, which is the one we've all been focused on because it's the largest numerical number, 0.23%. In other words, 5 times less than the Venice Commission recommends as appropriate. KZN, 0.24%. Limpopo, 0.43%. Mpumalanga, 0.63%. Northwest, 0.64%. The Northern Cape's the only one that's out, 1.67%. And the Western Cape, 0.43%. In other words, of the 9 provinces, only one exceeds the Venice Commission's limit, and that's because of the geographic peculiarities of the Northern Cape and how it all works. But all of the others are not just below, they are well below. In fact, most of them are not even 2/3 of the Venice Commission's report. Now, if the Venice Commission is to conclude that these, and I'll read the phrase again, that these are a core of good practice in electoral matters, and if Parliament has adhered to that approach, on what basis does this court say that is unreasonable, disproportional, and, to use the phrasing in 36, not reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom? Justices, that's Europe. Those are open democratic, maybe not some of them, but those are open and democratic societies based on human dignity, equality, and freedom. They all respect the right to vote. They have a principle laid down across all of them, and we are there. When you go to the provinces, as opposed to the National Assembly, it's even clearer. I won't read all those figures again, but they range from 0.12% at the bottom to the highest being 0.31%. And that's another important factor. If I am truly a candidate who thinks I may not be able to obtain 14,000 signatures, but I still want to contribute, I don't have to obtain 14,000 signatures if I choose to run for a province, a provincial legislature. I can go and run there, I can obtain significantly less signatures because the quota is lower. And so when we speak about the absolute numbers, with respect, it sometimes misleads. The percentage matters because the percentage demonstrates it relative to a quota. So where are we now? We have a situation where everyone now, finally, despite the case pleaded, concedes that it is a legitimate purpose to have some form of contestation requirements. We know that the requirement for contestation requirements didn't emerge from Parliament, it emerged from the Valley Musa Commission report. We know that the only benchmark you have been given, the only one, from all of the electoral bodies worldwide, is the Venice Commission, and we know that we are way under that. And the question is, can this court conclude on that basis that this is unconstitutional? Or more accurately, has this court been persuaded through evidence that this is unconstitutional? And that's why I go back to my first point. This court can leave the door open. It can deliver a judgment which says we have significant concerns about whether this is unconstitutional, significant doubts that this is unconstitutional because of Venice, etc. But we leave the door open because this case has not been properly pleaded on this basis. There is no evidentiary basis, and we decline to determine on an urgent basis, once and for all, that it's unconstitutional. Because, of course, once this court determines that 15% is unconstitutional, there's no going back. That is the law forever. It can never change. If this court adopts a Savoy approach and says facial challenge, abstract challenge, high benchmark, and leaves a gap, we can run the 2024 elections. We can see whether Zaki Ahmad gets his 14,000 signatures on the basis of his 44,000 Twitter followers. And the court will be able to consider that going forward on the basis of properly prepared papers. So, that leaves only 2 points. One is, where is the scientific method? And the second is the question of remedy. Now, on the scientific method, with great respect, sometimes our learned friends, and I echo what my learned friend Ms. Pillay said, argued this as though this is a judicial review. It is not a judicial review. It's not an administrative law challenge to say, what's in the Rule 53 record, let's set it aside. This, we know, is an objective facial challenge to a statute enacted by Parliament. And what that means is we're not engaged in judicial review. We are engaged in considering the following question. Assuming that there is a limitation of rights, and let me say I'm entirely with my learned friend Ms. Pillay to say there's no showing of limitation, but assuming there is a limitation of rights, is it reasonable and justifiable in an open democratic society based on human dignity, equality and freedom? And the question that then arises is, do you need a scientific study to show that? And in the absence of a scientific study, is there some constitutional defect? And the answer is no, for at least 2 reasons. The first is, I think my learned friend at the judgment of Nicro. My learned friend referred to the judgment of Nicro, which said sometimes you don't have things which are evidentiary capable. And of course, I say again, as she said, what kind of evidence would you expect? We've never run an election like this, so we don't know what the evidence would be. But secondly, we would refer the court to the notion of legislative facts dealt with by this court in S versus Lawrence, 1997-4, SA 1176, at paragraphs 42 to 43. Because there, Justice Chaskelson quoted Hogg as saying, while a court must reach a definite conclusion on the adjudicative facts which are relevant to the disposition of litigation, the court need not be so definite in respect of legislative facts in constitutional cases. The most that the court can ask in respect of legislative facts is whether there is a rational basis for the legislative judgment that the facts existed. Now, I accept reasonable because we're in a 36 inquiry. But then, importantly, what it says in this 3rd paragraph, the more important reason for restraint is related to the respective roles of the court and the legislature. A legislature acts not merely on the basis of findings of fact, but upon its judgment as to the public perceptions of the situation and its judgments as to the appropriate policy to meet the situation. Those judgments are political, and they often do not coincide with the views of social scientists and other experts. It is not for the court to disturb political judgments, much less to substitute the opinion of experts. Now, I'm not saying that means Parliament can do what it likes, but I am saying that if this court were to invalidate this law on the basis that there is no scientific study explaining 15%, that would be a whole new ballgame, and I'm unaware of any authority which stands for that proposition. I literally cannot think of authority which says where Parliament acts, it needs a scientific study for the lines that it draws. And we've drawn your attention to the Hugo case, where this court said years ago, a line has to be drawn somewhere. Now, obviously, there are polls. If Parliament was to draw the line at 80%, it would obviously be unconstitutional. But not because of the absence of a scientific study, because it's just patently unreasonable. But is it patently unreasonable to say We know that you need 100% of the votes to get a seat. And we're going to draw our limitation at 15%, not 100%. So that you know that you need 1/6 of the supporters that you would need to get elected. We submit that that manifestly satisfies these requirements. That leaves lastly the question of remedy. Now, we submit with respect that there are three options notionally available to the court. The one is to grant the relief sought by the applicants, and that's to read in 1,000, not for the registration requirement, but for this new contestation requirement. The second is the relief sought that we seek, which is that the court should suspend the declaration of invalidity, let the elections play out, no interim relief, and see what happens. And the third is something in the middle, which is the court must do the best it can to fashion some sort of middle ground. Now, we respectfully submit that the first one should not seriously be on the table. The IEC has said that in its view, 1,000 will not be enough to ward off the risk of confusing and lengthy ballot papers. That is not answered. I'm not suggesting that that is dispositive, but I am suggesting it should carry considerable weight with the court. The court will be slow in my submission to read in a requirement which, on its face, is extremely low and which the IEC has significant concerns about. On the other hand, I do accept, and although I press for it, I do accept that there is a difficulty in saying we've concluded it's unconstitutional and we're going to leave the limit as it is. But then what the court must do is fashion the best middle ground it can, whether it fashions it at 7.5% or 5%. You ask me how to do it? I don't know. But what I do tell you with respect is that if the court can't fashion a remedy, then it is in the world of Fraser. Remember what happened in the case of Fraser versus Children's Court, 1997. That was a case about the rights of unmarried fathers, of children born out of wedlock. And the court said it is unconstitutional to not give them rights over their children. But the court said we have to suspend, and we cannot fashion an interim remedy because one doesn't exist that neatly confirms to us. So what did the court do? It left Mr. Fraser without a remedy. It was sad, it was unfortunate, but that was what the court concluded because it was unable to fashion an interim remedy. And my learned friend points to Fourie as well. Sometimes the court has to accept that fashioning an interim reading in is not possible, and then it declares it invalid and suspends without more. And we submit that that is what this court should do. At the very least, what the court should do is fashion something in the middle, but the notion that the court should simply pick 1,000 because that was the figure from the previous regs for a different purpose, we submit is not sustainable. So for all of those reasons, we submit that the application should be dismissed or that remedy should be granted.
Thank you, Mr. Bartlinder. Justice Matopo.
Mr. Bartlinder, why is Nicro and Lawrence the panacea to all the problems that Parliament or the legislature may have tried to cure? Is there any other approach except those two cases?
Justice Matopo, let me answer the question in two ways. Firstly, we only get to the Nicro-Lawrence debate if you find that a proper case has been made out for limitation and that that onus has been satisfied. If the applicants haven't satisfied their onus to demonstrate a limitation, we don't even get there. But if you're against me on that and you find that the limitation stage has been reached, I submit that this is one of those cases where there is no concrete evidence that you can put up. Because it's not the sort, normally, let me give you an example if I may. Normally what the sort of evidence you would expect when a criminal law is changed is you would say, well, how many people have been convicted of the offense and how many people have done this and how. This is a new law which has never been used. So it would have been impossible to put up concrete facts. And therefore we're in the Nicro-Lawrence realm of policy considerations.
Sorry to follow up. If I understand you correctly, the invitation that you're asking us to accept is, among others, to say no evidence, either direct or indirect, has been demonstrated by the applicants. And if we are in that realm, then we have to find for the respondents.
Exactly. That's the first route, is you find that there is no evidentiary case to demonstrate a limitation of rights. Therefore, the application is dismissed on that basis, and you leave the door open to some other case, some other day, on properly prepared papers which properly make the case.
But should we make it as narrow as all that? And are we not going to be criticized for having not frontally dealt with the issues?
Chief Justice,
No, I'm not there yet.
I was trying to flatter you, Justice Matopo. Justice Matopo, you'll be criticized whatever you do by someone. That's the one thing I've learned. But if this court is leaving the door open to another case, it should write its judgment as narrowly as possible to avoid prejudging it in due course. So that's, but how widely you write, how broadly you write is your prerogative. My only point is you could leave the door open to another case post the 2024 elections.
So you contend that one has to find comfort in what Justice Madlanga said in Savoy?
I do. That there is a higher bar. There is a higher bar when you challenge a statute before it's even been used, when you challenge it facially and abstract. And you've got to show something. You've got to show a real problem. And that has not been shown on an evidentiary basis.
All right. Finally, on the last alternative ground, which does not appear to be attractive to me, of the ratio, how do we then lower it from 15 to 7 or 6? What would inform us? Because we're bereft of that expertise?
Yes. That is why my primary submission is you should not. My primary submission is you should say, if you're against me on the merits, you must say we declare it unconstitutional, we suspend, it will still allow independents to contest if they raise the required signatures, and we will allow Parliament to fix. Exactly as happened in Fraser, and I'm told Fourie, but I haven't read Fourie for quite a while, but I'm relying on my junior. He's normally reliable. But that's exactly. And it's a difficulty. All I'm saying is that the one route you absolutely should not do in my submission is just adopt the 1,000 because it happened to be there for a different purpose in a different set of regulations.
Well, the Chief Justice, during the engagement with your colleague, Ms. Pillay, put it to her about the shift and raised an issue that why is it suspicious that now, because independent candidates have entered the fray, the requirements have been upped?
Yes.
Is that suspicion founded? Because I seem to share it as well.
It depends whether by suspicion you have a pejorative label. If what you mean is that this change was prompted by the introduction of independent candidates, I have no difficulty with the proposition. It plainly was. It was what Vali Musa proposed in his report. If the suggestion is that this is, and I'm not describing this to the Chief Justice, but if the suggestion is that it's some Machiavellian attempt to keep independents out, then that is not warranted at all, because what you see is, firstly, it was proposed by Vali Musa. Secondly, it's for very good reason because of what I've called the vanity problem. And thirdly, when it was initially proposed in Parliament, it was 50% and it got revised down to 15% and applied to political parties as well. So there is no Machiavellian intent. But I accept that I accept if New Nation had never happened, I doubt there would have been such a requirement. It was that prompted Parliament to look at it, and I must accept that.
But isn't that cascading downwards, which is not informed by any evidence nor reasoning, problematic?
But with respect, can I distinguish between evidence and reason?
Okay.
It's not informed by evidence. It is informed by reason. It's informed by reason which says 50% is too high because you're going to make it too difficult for people to contest, and we're trying to weigh enabling people to contest but only viable candidates to contest, and 50% is too high, and let's go to 15%. Now, I accept it's not informed by evidence, but it could never be informed by evidence. There is no such evidence available one way or the other where we've never done it in an election. And so it's not informed by evidence. I accept that. But it is informed by policy, and that, Justice Matopo, is where Nicro and Lawrence come in. Because they say sometimes you can have a limitation which is permissible on the basis of policy grounds rather than on the basis of evidentiary grounds.
Thank you. I don't see any further indications from colleagues. Thank you, Mr. Butlander.
Thank you very much, Chief Justice.
You look like you are still ready for more.
Chief Justice, as you know, this may be my last appearance perhaps for some time, so I'm just relieved that it wasn't more difficult. Thank you.
No, thank you. Counsel for the IEC, maybe you should come forward. There may be questions for you, but before I check whether there are questions for you, are there any issues you wish to clarify?
Chief Justice, following the debate today, and in particular what was stated in regard to the position the IEC took, although it's covered in the IEC's affidavit, I think it's quite important from the IEC's perspective that the stance it has adopted is the independent electoral body tasked with organizing the election. It's quite important to explain. Now, one can read it, but it's important to look at the trend and why it comes to the conclusion that it comes. If I might take you to page 520 of the papers. Chief Justice, I'll need about 10 minutes, but I think it's quite important that the IEC's position be put on record and explained. And if there are questions that follow from that, but it does seem as if there may be some misunderstanding of why the IEC got to where it is.
Okay, you will have 10 minutes without us interrupting you. Thereafter,
I appreciate
we'll put questions. Okay, thank you.
Can I just
Did you say page 5?
520.
That is the paginated. I'm just checking whether my colleagues.
It's the paginated papers. It's
the paragraph.
It starts at paragraph 21 of the IEC's explanatory affidavit.
Okay.
And can I just state the obvious, that what the IEC concretely had to deal with previously was the issue of registration in the context of political parties. A very different notion from the issue of contestation now, which has arisen because of the requirement to accommodate independent candidates. Again, I state the obvious when I say that it's a new challenge and nobody can doubt that. What it has had to look at in relation to the past is trends in the past which may illustrate what could occur in the future. And remember, you have no certainty of what occurs in the future, but you've got to go into the looking glass in order to ensure that you can, as best possible, arrange a successful and manageable election. It starts off in 1994 when no proof of voter support either for registration or contestation was required, but there was some proof of support required for financial support. And that took place not by signatures or anything of that sort. There was an independent opinion poll which was funded by the IEC. Now, of course, not the best way to do it, but it was the only practical way to do it in that particular circumstance. Just bear this in mind, we're still an evolving democracy, and they've had to learn as they've gone along. That then changed with the 1999 elections because voter support for registration of political parties was required, and signatures for that. And that's explained in para 22. The 2008 amendment introduced came about because of a new challenge, because there was then the possibility of a bifurcated registration of political parties at a national and provincial level. And I'm not going to read everything that was said. They set out the number of signatures, but it was a new challenge because you now had parties registering at a level of the province and at the level of national. But an important aspect of that was that it wasn't just simply an illustration of the ability to garner support, but whether the parties could organize themselves. Now, of course, getting to the registration threshold was an illustration of some level of ability to organize, otherwise it could just be free for all. But paragraph 24 and 25, in relation to numbers and statistics, which is quite important for what you're considering, is quite significant. You'll see that in the 94 elections, 19 parties had participated and 7 gained representation. In the 99 election, 16 parties had participated and 13 got representation. Just take as your benchmark 1999. 16 parties participated, 13 gained representation. Compare that to 2019, when the number of parties had shot up to 48, but the number that gained representation had increased by 1. So you had a jump from 16 to 48 in participation. Representation went up by 1. And if you were then to compare that to the combined number of parties participating in the National Assembly and the Provincial Assembly, the difference is even more stark. Because if you go to 25.5, in 2019 there were a combined number of 78 parties participating in both. The jump from the 16 parties in 1999, which gained representation, was 2. So there was a dramatic jump in the number of parties who participated and the number of parties who got representation. And of course, from the IEC's perspective, what it had to do and what it has to do now is look at the trend. Because the trend indicated a growing number of parties. It had no indication of independent candidates. What it did know is there was a growing number of parties who participated, increasing the challenge for the election, but hardly a shift in material sense of the number of parties who gained representation. And it had to confront now that there are 332 parties presently registered. It's just given me a figure, and you can make a note of this because that's not on the papers. I asked for this. That just prior to the 2021 election, there were 272 registered parties. That's jumped up already by 60 to 332. The challenge for them is they don't know how many of these parties are going to participate. It's impossible for them to tell. Nor do they know how many are going to participate at the national level, at a provincial level, or at both. Now, having regard to those numbers in relation to political parties and managing that process, because they've already seen a trend of a growth of participants, but hardly any shift in representation in the contestation phase. They've now been confronted with the challenge, and of course the challenge is one they have to undertake because of what Parliament has said and what this court has said. Remember, they're an implementing agent. The best they can do is indicate in the present circumstances why they think certain safeguards are needed, not because they want to establish or make the law, but because they point to the practical implications of organizing a successful election. And of course, there's no doubt about their independence, and they've done it successfully from the outset by evolving over a period of time. And they explain in paragraph 29 onwards the challenges that they face if there isn't some sort of a threshold. And I don't think there's any dispute that there's a threshold requirement. Question is whether that threshold is effective. A longer ballot paper, or rather, more than one ballot paper. The difficulty, even with 2 columns, of confusion. You know, we can sit here and say, well, you can do it in a particular way. You've got to remember the voter profile as well, and the type of difficulty. The fact that the administration for it will increase, which will increase the amount of time for voter tallying, and the implication all of that will have. The cost increase. Now, of course, at the end of the day, you can simply take the stance, well, if that's the consequence, then that's the consequence. Without the threshold, you'd have to accept that any consequence could lead to multiple pages on a ballot. They can't predict that at this point in time, and then the election probably becomes unmanageable. In their words, and nobody has contested it. What they then deal with, and this is quite important, is the question that has been raised in this application: is the figure of 1,000 a sufficient threshold? And they express the view, having regard to the trend, that it's not sufficient and it's going to create the problems. Now, that's what they've been called to comment on, given that they're abiding, and that's what they comment on. They haven't gone into any other exercise of whether anything else would be required. They've just dealt with. They do say that they accept the figure that has been set by Parliament, in the Act itself, and from their perspective, it's a reasonable and rational figure having regard to the trends in the first instance and the challenge of setting to lower barrier, which would be multiple ballot sheets, difficulty logistically, choices being made by voters being compromised, and the like. And for that reason, they conclude by saying that the requirement of 1,000 supporting signatures will not suffice, and you would require a higher level of proof of support. They're not talking of registration now, because registration doesn't come into play with independent candidates. Proof of support for participation, for contestation. You need something higher than that in order to make it meaningful. Otherwise, there's going to be a lot of people coming in. The last figure they give to me, which is not in the papers, the 2021 local government election, 1,547 independents contested in the local government election, of which over 600 got less than 100 votes. So there's just now, of course, that number must be seen in the context of ballots per ward or whatever the case might be. This is going to be ballots for, that go to the 200 seats. It's a single ballot. The problem is far more challenging.
That's 52 people were elected.
And of the 1,547 independents in 2021 local government election, 52 were elected. So it's an indication of the logistical problem. Final point I want to say, from their perspective, it's a simple case. Whatever the law says, the IEC will have to comply with and will do its best. But they convey to this court that too low a threshold creates logistical difficulties for precisely wanting to achieve what you want to achieve, a free, fair, and manageable election. Chief Justice.
Do they provide their basis for saying 1,000 would not serve the purpose?
From the experience based on trends. In other words, when you look at the way they build up to why there should be a threshold level, remember all that they've got is the trends in relation to political parties. They've seen that grow from time to time and the difficulty. They indicate that it's too low from their experience. And bear this in mind, part of their experience is the number of people who were independents in the 2021 local government election and the number of people.
What was that figure again in the 2021 elections?
It was 1,547 independents contested, 52 were elected.
Yeah, there was a big gap between those elected and those who contested.
And also the number who contested, where they had a significantly lower threshold to contest, was quite significant. It's quite significant. They can't tell how many of those people would optimistically want to stand on the national stage without any hope of getting there. But it's also, but it is a significant number. From their perspective, elections are the right of people to speak and to vote, but similarly, that right has to be accompanied by the right to do so in a meaningful manner so that it can be organized meaningfully. And that's the IEC's position, Chief Justice.
Thank you. Justice Rogers.
Mr. Bam, you will have heard that I raised with Ms. Pillay the increase of the support requirement from 500 to 1,000 at national level in August 2021. That was by the IEC itself under the regulations under the Electoral Commission Act. Until the recent amendments, including those now in dispute, the IEC didn't, or did it, have a power to impose an eligibility requirement to contest. I'm now talking only about political parties. Did it have such a power under its regulation-making powers, or was it only, as it were, filter at the registration stage?
It was only at the registration level.
So I assume that would it be a fair assumption that when the IEC increased the level for national registration from 500 to 1,000 in August 2021, part of its purpose would have been to winnow out the no-hope parties.
Part of its purpose would be to weed out the no-hope parties and to test those parties which could sufficiently organize themselves for registration purposes.
So at that stage, at least for new political parties, it was thought sufficient that, because once they registered they can contest, as the law then stood, it was thought sufficient that the level of support should be at 1,000 for registration.
For registration purposes, yes.
Would it be fair to say that, and correct me if I'm wrong, at least on these papers, there's nothing to indicate that the IEC itself would have increased that level in advance of these elections, were it not, and of course IEC didn't do it even in the latest legislation, that's Parliament, but that the IEC itself would not have sought to increase that level in advance of our elections next year. It was only because of the introduction of independent candidates that this whole question of having what turns out on the numbers to be a significantly higher level of support to contest has come to the fore.
That is so, but can I indicate what we should be looking at if we look at figures? I took you to the figures at page 522, paragraph 25, for quite an important reason. Paragraph 25. You'll see, just picture the ballot. It went from 19 in 1994 to, at a national level, 48 in 2019. Still within the boundaries of what can fit onto a single ballot and manageable. They've now got to deal with the fact that there are a significantly higher number of registered parties. If these trends were to be followed, there'd be an increase in the number of political parties. That increase may be 10, 15, around that region if you were to look at the trend. But coupled with that is the increase in the number of candidates because of independent candidates. In other words, what the stance they took in 2021 was a stance taken having regard to the fact that it was political parties. They've now got a new challenge. And that's why they take the stance they do.
And that's, I don't know, the evidence is that there are now 332 parties. I don't know how many of those are moribund parties that contested once and how many are more recent. But there are certainly more parties registered than I imagine the IEC would like to see on a national ballot paper, but at 332. But despite knowing the trends from 1994 to 2019, I think in August 2021, when the support level increased from 500 to 1,000, I think were those the municipal elections were held later in that year?
The municipal elections
September
were held
or
later.
October, November?
Were held later.
Yes. But be that as it may, the IEC had all the trends of the elections up nationally up until 2019 and knew how many political parties there were in August 2021, and yet seemed to be content, given the only tool at its disposal, which was the registration support requirement, to go from 500 to 1,000, doubling it.
Can I just say, that's why it's so important to look at the figure I pointed to you previously. You looked at the number that was registered. Let's look at what participated and how that increased. So there may have been a dramatic increase in the number of parties that were registered. The increase in participating parties is illustrated in paragraph 24.2 through to 25.4. And that increase was as follows. 24.2 is 1999. So whatever the number of registered parties there were, 16 participated. 2004, that increased by 5. 2009, that increased by another 5. 2014, that increased by 3. And yes, there was a big jump in 2019. That was by 19. Now, the number of parties that had registered didn't give you didn't correlate with the number of parties that participated percentage-wise.
Yes, but, okay, so from 1994, where I think 19 contested until 48, which is 25 years later, there's an increase of about 2.5 times the number of parties contesting.
About 30, yes.
But that the IEC knew when they passed the regulations in August 2021.
But just bear this in mind. You're looking at the jump from 1994 to 2019. What you've got to look at is the trend from election to election. Now, what you may say is that having regard to the increase from 2014 to 2019 by 19, ought the IEC to have limited it to 1,000, or should it have put it at more? But from their perspective, they were dealing with a registration requirement in circumstances where the numbers that had up to that stage increased in participation still kept it manageable. All the fears and concerns that they expressed could still be catered for. Now comes a different challenge, and at the end of the day, it's a challenge unquestionably which comes about because of the inclusion of independence. It's a whole new world. The possibility of independence unrestrained or too low of a threshold, exceeding the number of parties who contested in 2019, is something that they've got to confront as well. And that's why it's a whole new challenge for them. And from that perspective, what they say to the court is a threshold that's too low. And they express their concern that 1,000 is too low. A threshold that's too low for contestation creates all sorts of problems, and they've set out the problems. I need not go with it. But Justice Rogers, the point I'm making is what you're putting to me considers the stance the IEC took in relation to parties. I've already given you an indication of the number of independents who contested the local government election. That's completely disproportionate to the number of parties who contested the local government election. But you had to cater for them on the ballot sheets, and in this instance, you had to cater for them in the ballot sheets in the specific ward in which they participated. Now, IEC does face an area of uncertainty. There's no question about it. If you're looking for certainty in the IEC's forecasts, well, there's nothing to look back on because we haven't had this situation. What it's hoping for is that as best it can, it is able to control the election. When I say control the elections, I don't mean outcome or anything. It is able to organize it so that it yields a result. And what it expresses is the concern. It doesn't talk about the correct figure. It doesn't talk about the correct percentage for the threshold. It does express the concern that that which has been put up is too low, and at that level, all the difficulties that it talks about. And you know, we can look at those difficulties and simply say, manage those difficulties. Come the actual nuts and bolts of the election itself, and you find that you're running into trouble because there's a problem with 2 ballots. And the other problems that they point to. There's a problem with too many faces on a 2-columned sheet. And for that reason, it's difficult for the average voter to make the choice. It takes more time at the polling booth. It's more time to count. Those are practical aspects which have a huge impact at the time the election is run. It's not a theoretical exercise. And what we need to try to do is, in a new situation, put ourselves into that future as best we can. And that's what the IEC has tried to communicate to this court, that to do so with a low threshold does create risks which they can foresee. It may never eventuate, but again, if it does, and from their perspective, there's a decent prospect that at that low threshold level it will. And they do have the 2021 number of independent candidates as one source.
Can I just ask at a practical level? I know in July draft regulations, amendments to the Electoral Commission Act regulations were promulgated for comment. Have those been finalized yet? Do you know?
I don't.
I was just trying to understand the practicalities of collecting elections. I got the impression from the draft amendments that the proof of the signatures can be submitted electronically. I'm not sure if the person supporting you can submit, if I'm the candidate, can you send your support to me electronically as a signature, or is it merely that once I've got 14,000 real ink signatures, I can submit them electronically to the IEC?
Justice Rogers, I must admit I'll have to take an instruction on that. I don't want to make a statement which may be factually
Well, of course, we don't have the final regulations anyway. But,
absolutely, but
I wasn't quite sure what the effect of the proposal is.
I'll take an instruction. In fact, I'm told I can get an answer right now. I understand from the legislature's mouth that they aren't final yet.
Sorry, that?
That they're not finalized yet.
Okay, that's as to whether they've been finalized.
Yeah.
Yes, thank you.
Can I just say this, and I don't think I need to beat that drum, but the IEC has also indicated that wherever this court goes, time is of the essence from their perspective, because by the middle of next month they have to put out the tender for ballot papers. They need to have consideration to vote, to contestants lists and the like. And they have indicated that from their perspective for proper organization, on this issue as well as the first issue, it would be of enormous assistance if something came out by the middle of September. They're of course not dictating to the court, they're just expressing what would help them practically. Justice Matopo, I understand that they're really not dictating. It is saying, please help us, whatever you do from a timing perspective, and come next year, May or so, we'll be grateful if they did get the help. I think everybody would be.
I take it as obvious that they are talking about mid-September if the elections were to be, is it the 14th of May or 18th?
It's got to be between sometime in May to August constitutionally.
Yeah, but because they don't know yet when the election date would be, and it could be on the first day that it's supposed, or the earliest day that it's supposed to be, which is what is about mid-May. So I assume that their 15th September is having that in mind.
No, it's for sorry, Justice Zondo, it's for an election in that period, in that constitutional period. That much they make clear on the paper.
Yes, but there's an earliest possible, constitutionally possible date, and the latest constitutionally possible date, isn't it?
Can I just say this, Justice Zondo? I don't know what goes into the thinking of the announcement of an election day. We're all ill-qualified. What politicians do is what politicians do. But they've got to be ready, or they've got to start planning on the basis that it could take place earlier rather than later. The date is outside of their control, outside of our control.
Yeah, as I understand the position, and I may be wrong, but from what I read in the papers here, the impression is that it can't be earlier than a certain date, which is not.
It's from, the period is, I think, May to August.
Yes,
and the simple point is, of course, if it's the last day of August, then
there is more time.
The leeway there.
Yeah.
But the problem is, they don't have control over it. We don't. This court doesn't have control over it, and nobody can read into what politicians might or might not do.
Yeah. Okay. Justice Kolopen has a question.
Thank you, Mr. Baum. Thank you for sharing that useful information and some of the stats. But stats can say different things depending from which vantage point you view them. It may be argued that the increase in the number of political parties and the relatively little increase in their success may well be an evidence of people having a lack of appetite to support political parties and seek alternatives. I mean, that interpretation is perfectly plausible from the same stats. Because I just want to put that in the context of the stats you shared with us with regard to local government elections. And the figure of 1547 candidates standing and 52 of them being elected is not insignificant. It's almost 3%. The experts here were working on 1 or 2% in a national scenario. So, secondly, bearing in mind that the turnout for the local government elections was very low, as low as 45%, the lowest, that stat has added significance. And the last point is that when one looks at the stats from 2021, then the independent candidates collectively garnered in excess of 400,000 votes, and that would have placed them 5th on a list of about 40. So there might be a trend elsewhere, which we must be alive to, and not simply say that increased numbers will definitely result in a decreased representation.
Justice Colopin, you make such an important point. Can I put a slightly different spin on it?
I'm happy you agree with it, but that's fine.
Firstly, you're absolutely correct that it may well be that there may be a desire of a percentage higher than anybody has imagined to move away from parties towards independence. Let's just assume that to be the case. For those who want that shift, it becomes that much more important that there is a threshold so that the participation of independents for the first time since '94 is an election that is managed. In other words, let's take your very argument and say, give those who wish to go to independence a proper opportunity. And just finish that sentence. In an election which can properly be managed so that they have a meaningful opportunity. That may well be a different way of looking at it, Justice Colopin.
Thank you. I take the point. Even though 50 voters were necessary to secure a nomination at local government election, and that became perfectly manageable. Yeah. But let's leave it at that.
Perfectly manageable in this sense. Remember that those numbers were spread across the country in wards. This is now at a national level. Justices, I don't know if there are any further questions. I think I've spent a bit of more time on my feet than anticipated.
No, thank you very much, Mr. Patton.
Yes, of course.
Thank you. Thank you.
Three areas. First, the rationality test. The court was taken to paragraph 128 of the founding affidavit. That's at page 41. So where the chief complaint was described as requiring both political parties and independent candidates to acquire the same number of signatures, 129 immediately after sets out the complaint. While on the face of it, it is a formally equal requirement, this results in a substantively unequal outcome, which creates an unfair barrier to entry. And the same is repeated in paragraph 50 at page paragraph 150 of the papers, where the complaint in this court was from paragraphs 148 to 150. This threshold is arbitrary. And the complaint was the arbitrary nature of this threshold can be demonstrated through the legislative process. And specifically at para 150, the applicant said, we didn't understand where the 50 came from, but whilst this was clarified later in the legislative process, the reduction went from 50 to 30 to 20 without any demonstrated rationale. Now, in their founding affidavits, the applicants referred to the submissions which they had made to Parliament and that's at paragraph 16.1 at page 14, and they incorporated the contents of those submissions by reference. They similarly referred to their submissions to the President, which was after the legislative process, and they incorporated those submissions. That's at paragraph 65. What those submissions and the core of the case has been is that we represent members who are individuals who do not have resources, who are in a materially different situation from more organized, relatively well-resourced political parties. So that is the basis on which the applicant has come to court on its own behalf and on behalf of its members. The basis is this is a barrier to entry. Now, I don't know what else by way of evidence the applicants could have provided, because at the time, the number was so prohibitively high that it would have been impossible to say, I went to 14,000 people and I couldn't get support. I went to 11,000 people or I couldn't get support. But the point is, these were new entrants into the electoral arena arising from a judgment of this court. Now, why is that important? It's because you were taken to the New National Party case and you were read the first part of the rationality test, which is a legitimate government purpose. There are two parts. And that appears at paragraph 25. Are they related to a legitimate government purpose? And Justice Yacoub says, you approach that approach in two stages. The first part is whether a facial analysis has been shown to lack rationality. That's not the case here. The second is whether these provisions can be said to be arbitrary or capricious in the light of certain circumstances existing at the date of the adoption of the statute. That is an objective test. And what this case revolved around were the ID documents in circumstances existing at the time of the commencement of the statute, in which 80% of the people had ID documents. 20% of South Africans had 10%, yes, 80% had ID documents, 20% did not. 10% had former TBVC documentation and would have been included on the voters' roll. So it was not a bar to their participation. Of that, there were only 10% left, 2 million people. But the department in that case came to court and said, but we have a system. We have a sufficiently flexible system in which people who genuinely want to vote can get a temporary ID in 24 hours. And it's against that backdrop that that case was decided, that the applicants had not demonstrated a breach of the fundamental rights provisions. Now, the objective facts in this case are very different. We have the New Nation judgment after a long, protracted battle. We have a 3-year process in which these precise objections were raised by individual candidates as a group, where they pointed pertinently to the differences. They pointed pertinently to the disproportionality between what was and what is to come. And it's on that basis we submit that it is self-evident, and indeed Parliament has accepted that this is a preemptive requirement on the ability to stand for elections. And I refer the court to paragraph 20.4, although they do it in brackets, 20.4 at page 565 of the papers. In brackets, which I accept as a preemptive requirement that operates before elections. In addition to that, we have the observations from this court in CALM, where the self-evident differences between political parties and independent candidates are described. We submit that we have demonstrated a breach of a right. On the second question as to whether the state has presented evidence to justify the limitation, we go right back to what was said in Moise, where if a constitutional validity of a section is challenged, it is incumbent on the state to present the law, the facts, and the policy upon which the decisions were made. That's at paragraph 18. They describe this as this court describes it as an obligation to do so. It includes not only the submission of legal argument, but placing before the court the requisite factual material and policy considerations. We're not saying that a scientific study should have been presented. We're not saying that something akin to the Venice Commission evaluations should have been presented. But what we are saying is that apart from a legal reason for this particular ratio, there has been no factual underlying basis. And then finally, we submit with respect to the remedy, we're not asking the court to read in this requirement forever. On the minister's own version, this piece of legislation is meant to cover the 2024 elections. Beyond that, it is hoped that there will be reform. So it is for the next election. It is not a question that can be left open with respect because of the impact of the independent candidates who cannot meet that signature requirement. It will be too late. And so we're not asking the court to legislate forever. We're asking the court to legislate to ensure participation.
Am I justified in thinking that you might not be persisting in the recalculation challenge?
We don't abandon the challenge.
Okay.
The point of the challenge was to demonstrate the breach of Section 9 and Section 16 sub 3 by allocating different weights and different values to classes of votes.
Yes.
While we accept that that is not indicative of the Section 46 standard, what we say is this is a Section 9 breach and a Section 19.3 breach. Whether it can be said to be justified in the circumstances is a different issue.
Okay, all right. Now, in paragraph 128 of your client's founding affidavit, which is paginated page 41, you did refer to it just a few minutes ago. The applicant's case is put as this: the chief complaint of OSA is that the Amendment Act requires both political parties and independent candidates to acquire the same number of signatures in order to register. Is there anywhere in the founding affidavit where the applicant or the deponent substantiates why it's a problem that both are required to get the same number of signatures?
In the founding
affidavit, which is where the applicant must make out its case. I've struggled to find it, but maybe I didn't look enough.
Beyond the description of the applicant as an association with members who intend to stand, and the deponent says, I speak for our members, this is an unreasonable barrier to entry. And beyond the attachment of the submissions and the incorporation by reference, no, Chief Justice, there isn't anything.
You know, isn't that a problem, because the applicant describes that as its chief complaint. So its chief complaint entails comparing saying, in other words, it is saying, why do you want us and political parties to meet the same requirement? What one would have expected is that somewhere in the affidavit, the applicant would then go on to say, here is how we are disadvantaged as opposed to political parties. Maybe if you did this to the political parties, that would have been fine. But then for us, because we are not political parties, it becomes unfair because of this. But the unfairness has to be connected with the fact that they are not political parties, they are independents.
I understand the question, Chief Justice.
Because you have got to say, when you look at this complaint, the way it's formulated, you've got to say it could have been, the applicant could have formulated its complaint as, our complaint about this requirement is that it's a barrier to entry. In other words, we don't have to talk about political parties. It's a barrier to entry for individuals because of the following reasons. But here, the applicant connects this complaint with the fact that both political parties and individuals are required to meet the same requirement. So one then expects that as one reads on in the affidavit, one will find more substantiation as to why it's wrong to have both being required to meet the same requirement.
Chief Justice, the application was drafted urgently, and it's for that reason that the submissions in the parliamentary process and to the President were put up and incorporated by reference. And that appears at paragraphs. And what is said, this letter describes the contention of OSA in this regard, and I respectfully incorporate its contents by reference. That appears at page 65. So the complaints were put up, but incorporated into the affidavit by reference. Paragraph 65, paragraph 16.1, and paragraph 16.4. Now, those allegations were not disputed.
It's not the best way of pleading.
It's not the best
to say the least.
But I will accept that, but it was an urgent application. The timelines were...
Because in your founding affidavit, you've got to tell the other side what case they should meet. And if you simply say, I refer to such and such an annexure, and it must be read as incorporated, I'm not sure if that assists, if you don't specify what in that annexure you are really relying on. There may be an SCA case that deals with this. I think there is, actually.
D.H. Wavell Trust.
Yes,
and
some hospital that was involved. I think it was referred to in a judgment of this court in Genesis, if I'm not mistaken, that you can't just refer to an annexure without pointing out what in that annexure is part of your case.
So, pardon me, Chief Justice. So on page 14, paragraph 16.1, the representations made to Parliament, which say this is who we are, under-resourced, materially different. Paragraph 16.1 says, I attach here to the written submissions marked B, I submit that these submissions reflect the content of the objections raised by OSA, and which I respectfully incorporate by reference into this affidavit. And those contents and their objections in the parliamentary process and to the President they were based on objective facts of being different from a political party to an independent. We would submit that it is self-evident, the differences, as recognized by this court, in capacity, in resources of political parties and independent candidates. Secondly, we submit that it is common cause that the signature requirement is a preemptive step to enter the election. The objective facts that government was aware of when this legislation was passed includes all the history.
But we're talking about the case the applicant has made out in this court. So, irrespective of what the government might have had, when one says, what is the applicant's case really here?
The applicant says...
Well, I don't want you to go back and tell us what you have told us before, but I'm just simply going back to my question, but maybe if you have said all that you can say in terms of how it was pleaded, that's fine.
I haven't, Chief Justice.
Yeah.
The applicant says this number is arbitrary. It's unjustifiably high. That must mean that they can't beat it.
But that might be another case. But in relation to political parties, it can't be arbitrarily, I would imagine. The applicant would have to tell us if it's saying it's too high for us as individuals, but not too high for political parties, therefore we should have been given a different requirement, because the complaint is, why make us meet the same requirement? Why put up the same requirement for us and for political parties? But when one wants to say, okay, why should it be different why should you have a different requirement and not the same requirement as political parties? Then in the affidavit before this court, it's difficult to find any explanation or motivation.
The highest that I can take the answer, Chief Justice, is reference is made to the fact that 1,000 up to now has been sufficient. And it is in that context that why make us equivalent to political parties refers to the higher figure. And so in there is a contention that this is unfair and it's arbitrary. But that's the second argument raised by the applicant, which is this is arbitrary because we don't understand it. We don't understand how this number came to be. We asked, but we were never told. And it's on that basis that they say.
The issue of irrationality is out of the way, is that correct?
No.
That's what you have been understood to say.
What is out of the way is that we don't dispute that the state respondents have a legitimate government objective in imposing a signature requirement, a demonstration of voter support.
As opposed to the actual number.
Yes, the arbitrary
Yeah,
unjustified number
yeah,
without explanation.
okay.
Now, I accept that my learned friend argues, well, what's arbitrary, what's disconsonant with linking it to voter support? The problem is, it has never been done before in our electoral system. Problem is, it's been 1,000 up to now. And now it is imposed with such numbers. And as the numbers themselves demonstrate, there's the difficulty.
Well, isn't the position that the IEC, doesn't the IEC explain that in its affidavit, and doesn't the minister and Parliament deal with that, but then there is no affidavit from the applicant subsequently saying those explanations are not good enough because of ABCD?
Well, we didn't file an affidavit replying to an explanatory memorandum by the IEC who abided. We didn't file a replying affidavit to the minister because the answer that is presented there is what we always had, which was the sliding scale, which we said is the problem. This is not a legislative choice. You have to consider the impact.
Yes, then the last question from me is on page one, on paragraph 129 of your client's affidavit. While on the face of it, that is page 41, paginated 41, while on the face of it, it is a formally equal requirement, that is the registration that is the same for political parties and individuals. This results in a substantively unequal outcome, creates an unfair barrier to entry for independent candidates, and goes against the purpose of New Nation 2. Now, I was able to draw my attention to a part of the affidavit where we are then given grounds why to substantiate the statement that this is an unfair barrier to entry. In other words, the substantiation of that. Where do we find the substantiation as to why is it a barrier and why is it unfair?
I have a minute. The closest, but it's not a factual assertion. The closest is on paragraph 139. Therefore, any requirements that are imposed on independent candidates to contest elections as prescribed in section 31B should be balanced in the context of these political rights and ought not to be treated as gatekeeping mechanisms nor as a barrier to entry. Chief Justice, you do not have a statement in the founding affidavit to say, I tried to meet these requirements, but I can't meet them. You do not have a statement to say, I will not be able to meet these requirements. But what you have is a collective acting on behalf of a defined group of people who have all said, through the founding affidavit, this is a barrier to entry. Meaning, you're keeping us out, you're locking us out. The only inference to be drawn from that, or the meaning in that, the only meaning that can be read into that, is we can't meet this requirement.
Yeah, but
that's as far as I can take it.
But if that's what you mean, isn't it the easiest thing for you to say that in the affidavit? Of course, yes.
I can only plead that this was an urgent application and that this is all in the submissions to Parliament. But the second plead is that it is self-evident that this is a limitation on the right to vote, where the only requirement in Section 19 is that you be an adult citizen.
The statement that this is a barrier seems to me to talk to practicalities. That's the meaning that comes to my mind immediately. It might not be the only meaning, but that's the one that comes to my mind, that it means practically you are creating problems for us if you say we must meet the same requirement as the political parties. But then I would have expected, as I say, more to say, okay, why? Why is it practically a barrier, a problem to say this and that and that and that, even if you don't have to say, I've attempted to try and collect X number of signatures and I've realized that it's a problem. Even if you don't say that, but I would have expected that the applicants would put up something to substantiate the case that it's a barrier.
It is an association speaking on behalf of its members
Yes.
through a founding affidavit. I accept
Yes.
it. It has put up its constitution. It has put up its resolution saying this is an infringement of our rights.
Yeah.
It has put up its submissions and incorporated those complaints.
Yeah.
But nevertheless, Chief Justice, may I do this? On its own, we are able to assess not just physically the extent of a province that would need to be covered to get these signatures. But we did a simple exercise this morning on how many hours, just using basic experience, how many hours it would take to get 11,000 signatures.
I'm giving evidence now.
No, with respect not, Chief Justice. With respect not. Assuming it takes 1 hour to go door to door and collect a person's details and introduce yourself, and assuming you do it by yourself, 5 hours a day, 11,000 hours,
Well,
3 years.
in the end, you want to say it's going to be practically impossible, which is what they should have said in the papers.
Well, that is the basis on which, self-evidently, this is unjustifiably high. If they haven't made out that case, then the complaint falls. But nevertheless, we submit that given the objective facts that were known to government at the time that this legislation was passed, the long and extensive battle that was fought by independent candidates to win the right to participate, that the applicant has demonstrated an infringement of the right to vote.
Thank you. I don't see any indications from my colleagues. Thank you very much. Thank you.
Chief Justice, we are grateful for the urgent hearing.
Thank you. Thank you. Thank you very much to all counsel for your submissions. The court will take them into account, and as soon as judgment is ready, the parties will be notified. Judgment is reserved and the court adjourns.
Yeah. We'll see. I mean, I think it's going to be